Good afternoon. I'm Ward 1 Councilmember Brianne Nadeau, Chair of the Committee on Public Works and Operations. Today is Wednesday, January 24th, 2024, and I'm calling to order this hybrid meeting of the committee in room 123 and on the Zoom platform. The time is 2:04 p.m., and this hearing is being live streamed at brianneknadeau.com/live. Today's hearing will focus on the Department of Licensing and Consumer Protection, or DLCP, and we'll hear from both government and public witnesses. DLCP was established in October 2022 as a result of the Department of Buildings Establishment Act of 2019. That act required the division of the Department of Consumer and Regulatory Affairs into two new agencies. DLCP retains the functions to protect the regulation of business, occupational licenses, corporations, the certification of weights and measures, and other non-construction permitting matters. The functions of DLCP are critical to the effective functioning of the district government and economy. I look forward to discussing this important work with our public witnesses and with Director Tiffany Crowe. Some logistics for today's hearing for our participants on the Zoom. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all others will have 3 minutes. We will be promoting everybody to the panel in just a moment. You need to accept that invitation in order to access your microphone and camera. And when I call on you, you'll have the opportunity to use both and provide your testimony. If you're having any technical difficulties, oh, and we have witnesses in person as well, right? That is the nature of a hybrid hearing. So we'll call folks up to the dais, to the witness table as well. For those of you in the Zoom, if you're having trouble accessing what you need, you can reach out to David Meny, who's listed as the committee staff, and he can follow up with you, or you can email publicworks@dccouncil.gov, and we will do our best to resolve your issue. Our public witnesses today include Griff Johnson, Quiet Clean DC founding member. And as I call your name, feel free to come forward and be seated or accept your promotion into the Zoom panel. Sabrina Rhodes, Empower DC, community organizer. Charles Debnam, DC Tobacco Free Coalition, chairman. McKenna Osborne, Children's Law Center, policy attorney. And Felicia Dantzler, president of AFSCME Local 274. So, wonderful. Should we begin with the witnesses who are here in person? Okay. When you're ready, you may begin your testimony. And you can see the clock. Yeah. Okay. I'm sorry to interrupt. Just make sure you hit the button for your microphone. There you go.
Thank you. Sorry. Good afternoon, Councilmember Nadeau and members of the committee. My name is McKenna Osborne. I'm a policy attorney at Children's Law Center and a resident of the district. I'm testifying today on behalf of Children's Law Center. Our more than 100 staff work with DC children and families, community partners, and pro bono attorneys toward a future where every child can grow up with a strong foundation of family, health, and education, and live in a world free from poverty, trauma, racism, and other forms of oppression. The conditions in a child's home profoundly impact their physical and mental well-being. When families are living in rental housing with poor conditions harming a child's health, like mold contamination and pest infestations, Children's Law Center works with them to advocate for necessary repairs. We need to be able to promptly notify a family's landlord of the conditions, and if the landlord fails to make the repairs in a timely manner, take legal action. To do this, our clients and attorneys need to know who the landlord is and how they can be contacted and properly served. It's not an easy task when a property's registered owner is an anonymous single-purpose corporation and not the actual person or persons profiting from operating as a housing provider in the district. Also, based on our experiences repeatedly coming up against the same negligent landlords, Children's Law Center has advocated for the Department of Buildings to proactively identify landlords who own multiple properties with poor conditions under different single-purpose corporations to strategically target the district's housing code enforcement. The Department of Licensing and Consumer Protection plays a crucial role in allowing Children's Law Center and the Department of Building to do this work. And that's why I'm testifying before you today. DLCP is responsible for registering all corporate entities that conduct business in the district, including the LLCs that own residential properties where our clients live. Under district law, corporate entities are required to provide DLCP with the name and contact information for a registered agent who can receive, process, and legal documents on the entity's behalf, and each person who is a beneficial owner of the entity. Entities are also required to update DLCP with any changes to this information. DLCP collects the information through corporations' initial filings and biennial reports, and it is publicly available on Core Online, the online corporate registry system used by DLCP. This is supposed to empower district residents with the information they need to understand who they're renting from and how to successfully contact them, and enable the district's Department of Buildings to proactively identify the worst landlords and hold them accountable. Children's Law Center appreciates that DLCP's Consumer Protection Unit may investigate an entity's disclosure if they receive a complaint alleging noncompliance. And we thank DLCP for engaging with Children's Law Center and this committee over the past year to discuss their beneficial owner disclosure practices. However, based on the agency's oversight responses, we remain concerned that DLCP is only engaging in passive implementation of the district's corporate transparency requirements and reactive enforcement. DLCP must make use of the valuable staffing resources that this committee secured for them during last year's budget season, and to increase their capacity to meaningfully enforce the district's corporate transparency laws. Specifically, it currently appears that DLCP still deems corporations in compliance with beneficial owner disclosure requirements if they submit any information in those sections of their filings, and it does not appear to have adopted any procedures to review whether entities are actually making complete and accurate disclosures of their beneficial owners in compliance with the law. We hope that the committee will use its time with speaking with the agency today to probe how DLCP can quickly fill the positions that the committee funded and increase its capacity to actually enforce the district's corporate transparency laws. Thank you for the opportunity to testify today, and I'm happy to answer any questions.
Thank you very much for your testimony, and I'll come back to you in a bit for questions. I believe that concludes testimony from people who are here in person, and so therefore we will turn to folks who are in the Zoom for their testimony, and we will begin with Sabrina Rhodes. Ms. Rhodes, you may begin when you're ready.
Thank you. Good afternoon, Chairperson Nadeau, staff and witnesses. My name is Sabrina Rhodes, and I am the community organizer with Empower DC, also ANC 5D02 here in Ivy City, Ward 5. It seems like there may be discrepancies and deficiencies in the current system of licensing that need to be addressed to ensure the safety of residents and communities. It's crucial to have a robust process that thoroughly evaluates businesses, especially those dealing with potentially hazardous materials. Can you see me okay? Okay.
Yeah, something weird was going on, but I don't think it was
Yeah, I
your
saw
fault.
that. Okay. On the DLCP's website, there's an important disclosure which states the Department of Licensing and Consumer Protection cooperates with other District of Columbia government agencies to ensure applicants' licenses comply with all applicable DC official codes and municipal regulations. The agency reserves the right to request additional documentation and or proof of inspections. The case with the National Engineering Products, the last time their boiler was inspected was in 2010, and electrical inspections, which did not pass in 2019. I will add there was a fire in 2018. Their general business license expired in June of 2022 and they continued to operate for 7 months before renewing their general business license, which was reinstated February 1st, 2023. The facility only has a certificate of occupancy and no air quality permits or any other licenses or permits to operate, but they use cancer-causing chemicals. What about a general business license should a chemical facility have the requirements to obtain? The category of general sales services business with subcategories listed with none that identifies with a chemical facility. The documents only required was the certificate of occupancy and a tax number, no permits, even though this facility uses chemicals, and was granted the license with no questions asked, and the fact that this business has been operating for decades was enough for DLCP. According to the DLCP website, the general business license is issued to such businesses as retail stores, online stores, consultants, etc. And a chemical facility is not listed under any of these categories. Let's see where I was at. There's no explanation of this statement. A number of other businesses that do not fall under an existing licensing category or which are not regulated by an existing national or local board of commission. I don't understand that statement, and there's no explanation for it. I'm testifying on the fact, which category would a chemical facility fall under? How does the owner or president of a one-of-a-kind chemical facility in a district that uses cancer-causing chemicals obtain a new license after operating for 7 months with an expired business license and using old documents because they have no permits or licenses? There should be stricter laws for polluters to obtain a business license. On the website, it directs one to review the directory to locate the applicable business category based on the primary business activity conducted in the district. The applicable business category in the subcategory is general business, which under the subcategory is general business. So if I wanted to sell toxic poop, all I need is a tax ID and a few documents. In the rest of my testimony, which I don't have time to discuss, is just ways that DLCP can go about strengthening their practices of giving out business licenses. This chemical plant is, like I said, is a one of a kind. There's no other chemical plants in the district. And the Department of Licensing should be stricter on polluters such as the National Engineering Products. Thank you for allowing me to testify, and I will be happy to answer any questions that you have.
Thank you so much for your testimony. We will now turn to Charles Debnam, DC Tobacco Free Coalition.
Good afternoon, Councilmember Nadeau and members of the committee. My name is Charles Debnam, and I am the chair of the DC Tobacco Free Coalition. We are a coalition of more than 50 local organizations and individuals committed to creating a tobacco-free community here in DC. Tobacco use is the leading cause of preventable death in the District of Columbia. Nearly a quarter of all cancer deaths in DC are attributed to tobacco use. And every year, over 800 DC residents die from tobacco. Tobacco use also has profound economic costs to our communities. According to the Campaign for Tobacco-Free Kids, $454 million in annual healthcare costs are directly caused by tobacco use, and $101.5 million in annual Medicaid costs are directly caused by tobacco use. Because of tobacco, every resident of the district pays an additional $843 in DC and federal tax due to tobacco-caused government expenditures. In 2021, the DC Council passed historic legislation to protect the next generation from being hooked by big tobacco by ending the sale of flavored tobacco products. This legislation was funded in 2022, and enforcement started in earnest by the Department of Licensing and Consumer Protection at the beginning of 2023. We recognize that enforcement of this legislation is not easy. There are more than 900 retailers that are authorized to sell tobacco products in the district. While the vast majority of these retailers had no problem complying with the law, many had intentions not to do so. Because of the proactive efforts of the agency to visit each of these retailers and ensure they were in compliance with the law, the number of retailers still selling illegal tobacco products aimed at hooking kids has decreased significantly. DLCP has also taken complaints from members of the public and made site visits as a result of those complaints. In an effort to speak directly with the community, the agency held community roundtables throughout DC last summer, and our coalition members were proud to participate in those. We are making progress, but more work needs to be done. DLCP needs additional FTEs to be able to expand its current proactive site visits to tobacco retailers. This is the single most effective way to ensure illegal products are not being sold in the district. DLCP staff, including the Chief Enforcement Officer, Robert Finley, have met regularly with our coalition to give us updates on enforcement and work proactively with us to improve the enforcement of the law. We also applaud the agency for its fantastic map outlining each tobacco retail license holder. In 2024, we urged DLCP to put up a map of retailers that have received notices of infractions in violations of the law. Excuse me. This will allow the public to help the agency by making our own inspections and submitting complaints if needed to the agency. Currently, tobacco law enforcement is done by multiple local agencies, and they are not always on the same page. So we urge the council to consider having the leadership of each of the agencies responsible for tobacco law enforcement to meet quarterly, share data, give an update of the work that they are doing, and discuss how they can work better together. New tobacco retailers continue to pop up, particularly near schools. We recommend that advisory neighborhood commissions gain similar responsibilities in tobacco retail licenses as they do with alcohol retail licenses. And finally, it has come to our attention that DLCP, that somehow there is no longer a specific enforcement mechanism prohibiting retailers from selling tobacco products to individuals under the age of 21. This is deeply concerning, and that this needs to be addressed swiftly. We recommend a Class 1 civil infraction with fines starting at $2,500 and doubling with each future violation. Thank you for your time. We are happy to meet further with you and any member of your committee to work on these policy suggestions. And together we can continue to improve our tobacco laws and their enforcements to protect our kids and save lives. Thank you very much.
Thank you very much for your testimony. That concludes our testimony from public witnesses. So let's do a few questions here. I'm sorry, I called you earlier. Come on up. Oh, that's okay. No, called you up top. Okay, so go ahead and, Mr. Johnson? Yes. Yep, go ahead. When you're ready, push that button. Just do your best. Okay. Thank you. Okay. When you're ready, you may begin.
Thank you. Good afternoon, Chairperson Nadeau and council members George, Pinto, Robert White, and Trayon White. Thank you for giving me the opportunity to testify before your committee this afternoon. My name is John G. Johnson, Jr. I'm here today to testify on behalf of Quiet Clean DC, QCDC for short. QCDC is a voluntary association of DC residents formed in 2015 to address public and private health, environmental, and social justice concerns arising from the use of gas-powered leaf blowers in our city. As you know, former Councilmember Che introduced legislation in 2017 to phase out the sale and operation of gas-burning leaf blowers in DC over a 3-year sunset period. Following a hearing before the Council's Committee of the Whole in July of 2018, the bill was unanimously adopted by the Council in December of that year. It became known as the Leaf Blower Regulation Amendment Act of 2018. In today's testimony, I'll refer to the law as the Act. QCDC, our organization, played an active role in the Council's consideration and adoption of the Act. Our organization actively sought support from the bill from advisory neighborhood commissions in all 8 wards of the city. We met separately with every then serving member of the council or with his or her staff, including yourself, Mr. Robert White, and Mr. Trayon White. I'm pleased to report that the council's adoption of the act has been cited by numerous other municipalities, including some of our neighboring jurisdictions in the state of Maryland, as a landmark event. It has spurred the enactment of similar legislation in localities across the nation. DC has distinguished itself as a leader in moving our country forward in promoting health, safety, environmental sustainability, and socioeconomic equity. QCDC has taken an active interest in the implementation of the Act, which went into effect on January 1, 2022. Since that date, it has been unlawful for individuals or enterprises to sell or operate gas combusting leaf blowers in DC. Violations of the Act can result in a civil fine of up to $500 per incident, plus penalties and fees. Enforcement of the Act has been assigned to what's now the Department of Licensing and Consumer Protection, or DLCP. QCDC has been working with DLCP's Office of Enforcement and its Consumer Protection Unit, and specifically with Robert Bo Finley and his staff, to ascertain the effect that the new law is having. With Mr. Finley's assistance, we've been tracking the number of complaints filed with DLCP alleging violations of the Act and the disposition of those complaints. We at QCDC have been pleased with DLCP's performance, accessibility, and responsiveness in providing us with updates on the number of reported violations of the Act and the number of resulting notices of infraction, which we refer to as NOIs, that have been issued by DLCP. We commend Mr. Finley and his staff for their diligence and their cooperative attitude and performance. There are areas where DLCP's ability to collect and publish data on the effectiveness of the Act and its enforcement can and should be improved. Mr. Finley has indicated that the Consumer Protection Unit would benefit from additional resources, including funding, staffing, and equipment, to enable that unit to establish a public dashboard that could be regularly updated on the number of complaints filed, the NOIs issued, and their dispositions. QCDC supports improvements that would enable the public to have more ready access to up-to-date data on these matters. In addition, and because the recipient of an NOI has various options for responding or not responding, we'd like the dashboard to incorporate information on dispositions of NOIs that may take place both within and outside the jurisdiction of DLCP itself. For example, was the recipient of the NOI assessed a civil fine? If so, what was the amount assessed and what was paid? If the recipient of an NOI chose not to contest the NOI, and if the matter was referred to the Office of Administrative Hearings, the dashboard should provide updated reports on the status and the eventual outcome of any litigated or settled hearing, including any appeals from the hearing officer's determination. 3, if the recipient of an NOI chose to ignore the NOI altogether and not respond, the dashboard should provide an updated report on whether that resulted in a default judgment against the recipient, and if so, whether that judgment was referred to the DC Central Collections Unit, whether efforts were then undertaken to collect the judgment, and the outcome of those efforts. To be clear, our interest in this is not solely to pursue enforcement punitively for its own sake, though obviously the Act requires compliance. and willful or repeated noncompliance must not be tolerated. But we believe that appropriate publicity surrounding effective enforcement becomes itself a deterrent to noncompliance. The more the public, including individuals and businesses, become aware that the Act's provisions are being effectively enforced, there will be a lessening of noncompliance and a reduction in the need for enforcement going forward. I'm sorry I'm over my time. I'll thank you for your time and consideration of our viewpoints. Please feel free to reach out to us at our website, quietcleandc.com, and I'm happy to answer any questions.
Thank you so much. I will jump right in with questions for you. I do intend to take this issue up today in our questions with the director, Mr. Johnson. I have received reports that there are retailers in the district continuing to sell gas-powered leaf blowers. Is that something that your organization is aware of as well?
We have not been monitoring that.
Okay.
I don't know that that's the case.
Do you think there would be an opportunity to include data on the retailers in any public-facing dashboard or data as well?
Yes, there could be. And Councilmember Nadeau, I believe that the Act incorporates a provision. I'm going back to what Councilmember Che drafted at the time. I believe the Act I may be wrong about this, but I believe the Act incorporates a provision that allows retailers to sell non-compliant equipment in the district so long as it is labeled that it cannot be used in the district. So,
Got you.
because
Very
there are
helpful.
neighboring jurisdictions where companies or individuals may reside and operate where it is lawful to use that equipment.
That's a good point. Thank you very much. Appreciate that. And Ms. Osborne, thank you for your testimony as well. We do have questions about beneficial owner in the discussion we're going to take up later today with the director. What is the process when Children's Law Center comes across inaccurate disclosures? What do you do next?
So how we come across inaccurate disclosures is we will have the LLC's name available through Property Quest or Scout, which the Department of Buildings uses. And then our attorneys will look at Core Online to see who the registered agent for the property is and or who the beneficial owners are and their contact information to try to ascertain who's really the landlord who has responsibility over the repairs and who we can notify of the issues and make requests and possibly sue for the repairs. When we realize that information might not be correct when, for example, the address listed is the same building as the one that our client lives in, and we know that that's
Not where
not the right address.
Yeah.
That's not where we could access the person that we're trying to serve. We've also had some of our investigators and attorneys when they're trying to they try to serve landlords or registered agents, and then no one shows up to court and we just can't be sure. We can't find any other information tying the individual to that address. So we're not sure if it was the proper place to serve them or not. And also we've had at least one instance where, for example, a registered agent will say, I didn't agree to be the registered agent for that entity. And usually we're doing this in a very time sensitive situation where there are serious repairs that need to be addressed. So our attorneys and investigators are focused on finding the correct information. And so we'll look to other sources to do that, to move forward with our case. I have been in communication with the head of the corporations division at DLCP, and they've recommended submitting complaints to the Consumer Protection Unit. As far as I'm aware, talking to our attorneys, they haven't done that necessarily in any of these cases, but we're definitely open to that moving forward. But at that point, it would really be a reactive mechanism versus making sure that the correct information is disclosed in the first place. So certainly open to engaging in that, but also want to make sure that there's emphasis and resources being put on the front end of disclosure.
You mentioned something that reminded me of something that I had to deal with on the consumer side. So a registered agent not being aware that they are the registered agent. So I had to, when I lived in a condo building and we had to create the association, it was like an LLC. And so you have to have a registered agent, right? And so when we were registering, it was like a drop-down menu of registered agents you could choose from. Not necessarily someone we had a relationship with, but someone who was, and there was no conversation. We would just select that person and then our application goes into the system. So now I have more questions about how that works. But do you know anything about that? Like how someone becomes a registered agent?
I am,
Probably
don't
beyond
have
what you're
details
normally
on
working
that,
on?
no.
Yeah. Okay. Well, that's something that we should disentangle. Maybe not today, but just to, yeah. And that was a couple years ago. So maybe it's different at this point, but it was a kind of a weird process to begin with, like who is a registered agent and how do you end up with a particular registered agent? And it's not like you can just say, oh, this is my lawyer, so that's my registered. Maybe you can now, but that perhaps is contributing to part of the problem too, when someone's saying, I don't know why I'm this person's agent listed on the documents. Okay, so that's helpful to know. And then when you've brought these concerns to DLCP, sort of what's the conversation? What's the reaction?
So we very much appreciate that DLCP has taken meetings with us and had conversations with us about the concerns we've had, the experiences we've had, and some of our suggested recommendations. For example, we had a meeting with DLCP last year about what we think could be some changes made to the filing forms that DLCP uses for corporations that could, if it were a little clearer and organized differently so that it was really requiring people to specify which type of beneficial owner they're reporting, because there's two prongs of beneficial ownership, and also indicate the percent of a beneficial owner's interest if it's greater than 10%, and potentially also actively check a checkbox saying, I certify that there are no other people with greater than 10% interest in this entity, that it could increase voluntary compliance, make it clearer to corporations who they're supposed to be reporting, and gather that information in a way that's easier for DLCP to check and for residents to use. I have looked at the most recent versions of those forms, none of those kinds of changes appear to have been made. I do understand from our conversations that there were concerns about their technology limitations on making those changes, and that DLCP was in the process of potentially getting a new corporate registry system and other technology, and they wanted to hold off until they had that in place to make any of those substantive changes. But I do think things like that are important to explore, because that is that's going to take a lot of the effort off of the agency having to reactively try to chase people who are not reporting accurate information. And because we really don't have a sense right now of who's willfully non-complying because they're trying to obscure ownership identity, and who's just not understanding what's supposed to be reported. And so we want to continue engaging with DLCP about those conversations and thinking about how they can increase their education as well as their enforcement.
Great. Thank you so much. I'm going to turn to Ms. Rhodes, if you're still with us. Very good.
I'm here.
Thank you so much. Okay, so thank you very much for your testimony. I wanted to sort of unpack some of the regulatory processes you've gone through to address the issue in your community.
Mhm.
So what other government agencies have jurisdiction over this, and what has the experience been trying to work with them?
Well, right now, it's the Department of Buildings, and of course, the LCP and DOEE, who is their DOEE and the EPA is currently doing monitoring in our community because of the fumes that's being emitted from this chemical plant. But right now it's just DOB and Department of Licensing. Also, Councilmember Parker has, and Connor has come up with the Environmental Justice Amendment Act of 2023, which should help with this issue of this chemical plant operating the way it is. I'm not sure exactly who else would have jurisdiction over this chemical plant, to be honest.
Sure. And because what I want to understand is what role DLCP does or can play in addressing your concern, because I know that they have a sort of a smaller role here, and I think what you're talking about is the licensing piece.
Yes.
Now, understanding the community's concerns about the environmental impact,
Mhm.
right? And that would be under DOEE.
Mhm.
DLCP may not have the ability to say yay or nay from a licensing perspective based on that environmental concern. And so I just wanted to get at what you think your understanding is. What's your understanding of how DLCP can help with that, given their sort of smaller role? Yeah.
Yeah, that was part of it. They couldn't say yay or nay because they said it's a business and they operate in a district and they need to have a business license to operate in a district. But because I'm saying DLCP is supposed to protect the consumer from any business that is unlawfully operating in a district. Now, how would they know that they're operating illegally in a district? Well, they don't have an air permit. They never had an air permit, and that should be one of the red flags that they should have asked for. Do you have an air permit? What other? Now, I was working with Marshall Harris, who is one of the representatives, and she really stuck in there with me until her hands were tied because of the fact that DLCP don't cover chemical facilities. No, no agency cover chemical facilities, and this facility uses chemicals. So how can DLCP strengthen their licensing process to cover a chemical plant? Otherwise, they'll continuously operate with just a general business license.
And is that request because you don't feel like the Department of the Environment has adequate tools on that?
Well, that's what we're working on now.
Okay.
We're working on now, but I help me understand this chemical plant. In order for them to have a license, would they need to go through EPA or DOEE first?
So I don't want to misspeak, but I can say that a basic business license is typically its own thing, right? And so if an entity has other rules governing it, typically that would fall to the agency that regulates that. But let's get into a little bit after the hearing, and we can see what makes sense. Certainly, I care about environmental protection and public health and want to make sure that it is clear which agency has that authority now and in the future.
Yes, and we would like for you to support Councilmember Parker in this Environmental Justice Amendment Act of 2023. That is very important because then the Amendment Act would help the polluters go to the right entity and have the correct documents. And if they're not allowed to do business in a district, then they would know that and they wouldn't do business in a district.
Absolutely, right.
Yeah.
You know, I think that sort of like the major tool that we have right now for, I'm gonna say quote, bad actors is clean hands. Right, so if a business has been fined and has not remediated and has not paid those fines, then they can't necessarily get their license. But if a business is being fined and paying off the fines and paying off the fines, then that doesn't actually help at all. So definitely something I'm happy to get into with you a little bit more, even if we can't resolve it today.
Because I didn't check into whether they had clean hands, and because they were operating past the grace period, they still, I guess they paid the fine and was granted the business license, which
Yeah.
they shouldn't
Right.
have.
Understood. I definitely understand you're looking for an angle to try to keep the community healthy here. And
Yes.
so I appreciate you coming to this hearing to raise it, to see if there's a way that we can assist, and we'll definitely look into that.
Thank you. Thank you.
Absolutely. I wanted to ask Mr. Debnam, could additional community outreach help with, you know, with public knowledge of the flavored tobacco ban? And could that help by increasing community complaints? Is that something that would be worthwhile?
Yeah, I definitely think community outreach, community engagement is always effective. And as you know, and you've always been supportive of this, and we thank you for your support. We've done a number of outreach activities even before the bill went into effect. DLCP played a big role in doing a lot of these roundtables that were done in pretty much all of the awards in DC to get the information out, to educate publics. We actually even did, meetings with ANC commissioners. We actually went to some of their meetings and spoke on the topic. So yes, so outreach has been done, I think, but more can always be useful.
Thank you for that. And do you have any thoughts on on why enforcement of underage sales may have lapsed?
That's, we that just came to our attention pretty recently, and we know that that falls under the Department of Behavioral Health and their SINAR program, Tobacco 21. So we're not quite sure. We're still trying to get information on that too, but we just thought we'd bring it up because it's something that we need to really address pretty quickly.
All right, well, we will get to work on that with the agency. Thank you. So that is everybody who signed up to testify in advance. I just want to make sure there's nobody else in the room or on the Zoom that is hoping to provide public testimony before we move on to our government witnesses. If you are an attendee in the Zoom and you're wishing to testify, if you could raise your electronic hand, that would let us know. But otherwise, we will turn to our government witness. Going once, going twice. All right, we're going to turn to our public witness. Okay. So I will now call Tiffany Crowe, Director of the Department of Licensing and Consumer Protection, to the front. Okay, Director, if you would, raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
You may begin your testimony.
Good afternoon, Chairperson Nadeau, council members, and staff. I am Tiffany Crowe, Director of the Department of Licensing and Consumer Protection, also known as DLCP. I am honored to testify before you today on behalf of Mayor Muriel Bowser to provide a brief overview of the agency's accomplishments and our priorities for FY24 and beyond. I would like to start by thanking Mayor Bowser for her leadership throughout her historic 3 terms and for trusting my experience and qualifications to lead DLCP as its first permanent director. Mayor Bowser, the city administrator, and all of her deputy mayors have been more supportive than I could have ever imagined as we seek to do things in a new way during this pivotal moment in the story of the district. Although the COVID-19 pandemic is a few years behind us, economic challenges still remain. We all have seen news stories about small businesses and restaurants that have closed, and announcements about major moves out of the city present new economic challenges to the district. Yet, where there are challenges, there are also opportunities. We at DLCP are doing our part to see Mayor Bowser's plans for full revitalization in the District of Columbia come to fruition and have ideas for helping to reimagine downtown DC and other parts of the district for business owners, residents, and visitors. Next, I want to thank Team DLCP. We are truly a team, and I thank every member of that team for giving feedback, encouragement, leaning into our motto of continuous improvement, and for trusting me as we head into the next stages of our work. Even when we deal with hard things and have hard conversations, we do it as a team with our goals in mind. The staff at DLCP is the most dedicated group of people I've had the privilege of working with, and I'm proud to be part of the work we are doing for our city. I also want to thank the council for their support of our agency's work and mission. I am glad to have met with you, Chairperson Nadeau, and your colleagues to discuss how the council and DLCP can work collaboratively for the benefit of the district. We are aligned in our desire to make it easier for prospective business owners to become licensed, existing business owners to renew, and consumers to have their issues investigated in a timely and thorough manner. We are excited for further collaboration with the council. The Department of Licensing and Consumer Protection is one of the district's newest agencies, established on October 1st, 2022. DLCP's mission is to protect the economic interests of residents, businesses, and visitors of the District of Columbia. We do this by regulating and providing licenses to businesses and professionals and investigating and enforcing the Consumer Protection Procedures Act, also known as the CPPA. The agency's services include issuing business and occupational and professional licenses, registering corporations, inspecting weights and measuring devices like those at grocery stores and gas stations. We also issue special events permits and protect consumers through education, regulation, investigation, and enforcement activities. Fiscal year 2023 was one of great change. During DLCP's founding year, the agency was able to meet or exceed nearly all of its key performance indicators and workload measures. In FY23, the agency also began implementing several laws that went into effect, including, but not limited to, the Street Vendor Advancement Amendment Act, Cashless Retailer Prohibition Act, and the Flavored Tobacco Smoking Device Amendment Act of 2021. Street vending, also known as sidewalk vending, has been a key priority of the agency since the act went into effect. And although the act was not funded until FY 2024, DLCP began its outreach efforts in FY 23. The agency conducted a series of workshops that reviewed the existing license application and renewal process, but DLCP is working with sister agencies including DC Health, the District Department of Transportation, DC Fire and Emergency Management Services, and the Office of Tax and Revenue to finalize this year's updated workshop calendar. In addition, in FY23, DLCP worked with DDOT, the Office of the Chief Technology Officer, and Microsoft to create a digital process for vending licenses. This work is ongoing, but has already made it easier for vendors to apply for licensure and for us to work with DDOT on site approvals. Along with this update to the application system, we are working on enhancements to the vending zone map. Once completed, licensees will be able to easily identify all permissible vending zone locations. Even during its inception, the agency made great strides with transparency. First, in response to the flavored tobacco law, the agency launched a map that shows the locations prohibited from selling electronic smoking devices due to their location within a quarter mile of a middle or high school. Working with Octo, we regularly update this map. We also wanted the public to be aware of our key performance indicators and other important metrics. To that end, a public dashboard specific to DLCP was created. This dashboard is updated daily, and we hope to roll out additional features this year. I'd also like to share a few of my key priorities moving forward. In addition to supporting Mayor Bowser's plans for revitalization and helping ease the path to entrepreneurship in the district, DLCP will continue to prioritize the needs of the DLCP workforce, improving our tools and partnerships, creating stability and credibility, and stimulating economic growth and business innovation. As I indicated at the beginning of my remarks, promoting a healthy and happy work culture is paramount for the operations of all organizations. DLCP is no exception. By listening to the needs of the team, taking their ideas and feedback seriously, and ensuring that everyone is in the right role, we are improving morale and making our mission clear. Over the past 4 months, we've been able to hire 13 new team members from outside the agency, most in critical executive or managerial roles, transition 5 staff members into new roles, and are actively recruiting 26 other positions, and 11 of those have onboards pending. I'm humbled every day by the talented individuals who work at the agency and who have agreed to help me lead the new agency. And now that DLCP's leadership team is in place, we can move multiple work streams in parallel while continuing to build morale and create opportunities for the advancement of our staff. We are also reimagining our tools and partnerships. Prior to joining DLCP, I worked as the Associate Chief Technology Officer for the district. In this role, understanding data systems, technology, and enterprise applications was central to my work. Early on, DLCP managers and staff told me about their challenges with our tools: technological, operational, regulatory, and administrative. I was simultaneously gathering information from council members, community stakeholders, and business owners. It became apparent very quickly that the agency's IT infrastructure was in dire need of attention, and that we must make investments in our legacy systems while building new ones. Without those parallel investments, we will never have the customer experience the district deserves. We are doing this through a few major projects that are already underway. Our business licensing, communications, and IT teams have been working with Octo and our vendor Microsoft to continue building the DC Business Portal. These enhancements will allow the agency to add all of our business licenses to a centralized system and improve efficiency and the processing of new and renewal applications. Additionally, we recognize that DLCP does not do its work in a vacuum. We will continue to work with our sister agencies, including the Department of Buildings, the Alcoholic Beverage Cannabis Administration, DC Health, the Department of Small and Local Business Development, and the Deputy Mayor for Planning and Economic Development to support small businesses and residents. We will continue to work with the Office of the Attorney General and other stakeholders to draft and review legislation such as amendments to the CPPA underway and our joint mission to protect consumers. Continuing my commitment to creating stability and credibility, we are improving the experiences our customers have. DLCP will continue to seek feedback from the business community and the customers we see every day. I've asked the team to escalate any concern about our systems or processes because every piece of feedback is valuable during this period of stabilizing and planning. Rather than relying solely on the executive team as points of contact, we have ensured that there are points of contact at all levels of the agency. This will create a more seamless service delivery for our customers and build ownership and accountability within our teams. Finally, we will continue working on our branding and messaging so the public knows that we are not only focused on enforcement, but helping businesses to become licensed so that they can fully participate in the district's economy. Finally, as mentioned at the outset of our testimony, we have an amazing opportunity to now create an economy of the future in the district. We have all the elements needed: motivated government officials, agency heads in sync, and a business community willing to engage with us collaboratively and productively. The LCP has been initiating meetings with our sister agencies and other business stakeholders to address specific issues they may be facing as we vet innovative business ideas or refresh buildings for new use. We are also in the process of establishing a market research function that will follow trends in consumer protection, regulatory compliance, enforcement, business licensing, and customer service. These actions in concert create an environment that rewards innovation and supports businesses that are supporting the district. Chairperson Nadeau, DLCP is living up to the agency's mission, and the team is exceeding my expectations in terms of motivation and willingness to do the hard work it will take to accomplish our short and long-term objectives. I believe and see this reflected in the dedication of my staff that everyone deserves a fair shot at economic prosperity here in the district. This is not an impossible dream. We believe that we can make that a reality by making our services accessible, reliable, and modern. Thank you for the opportunity to testify on behalf of the Department and Licensing and Department of Licensing and Consumer Protection, and I look forward to answering any questions you may have.
Thank you, Justice. Thank you very much for your testimony.
Thank you.
Okay, so I'm going to start today with a few questions on the cashless retailer enforcement.
Okay.
So the Cashless Retailer Prohibition Amendment Act was passed in 2021. DLCP began enforcing the law October 1st, 2023, due to safety concerns related to the COVID pandemic. Recently, businesses have raised concerns about keeping cash on premises and how it leaves them open to theft, threatening their livelihood and the safety of their workers. Currently, Councilmember Pinto has included a provision in her omnibus for public safety legislation to delay enforcement until January 2025. Now, in your pre-hearing responses related to the Cashless Retailers Prohibition Act of 2019, you mentioned that about half of the businesses who receive complaints have been brought into compliance. What's been the most common reason that businesses have been cited or that DLCP has observed for not being in compliance?
So I would say some businesses have cited safety concerns,
Mhm.
but there hasn't been one business that cited a safety concern and they didn't also cite sort of a preference for cashless. So it's sort of business operational preferences as well. And we're not, not taking that into consideration, but we do talk with the businesses and find out kind of, well, what operational concerns do they have? So for instance, one business, they have 4 or 5 locations throughout the city. They opened at the start of the pandemic, and so their entire business model was cashless, right? So when they hire people, they tell them, you won't have to worry about carrying cash out of here. We don't take cash. They built tipping into the way that they charge and the way that they pay their staff. And so their concern was not just safety, but because they are like, this is our entire business model. We'd like to better understand how we can come into compliance in a way that doesn't disrupt that. And that's where those like cash to card machines come in. And so we're working with businesses to find innovative ways to come into compliance rather than not enforce the law.
That's helpful. Thank you. And you also mentioned you've only encountered one business with a cash to card device, which for those who don't know is a machine that loads cash onto a prepaid card to allow consumers to complete a transaction at a business that does not accept cash. Why do you think the use of these machines is so low?
I think cost in some cases, it's about the cost of a regular ATM, so about $6,000 plus the maintenance fees. Probably there's some risk associated with it and just sort of like the relative value. So if you're going to spend, $6,000 and then have a maintenance fee for, I don't know, 1 in 1,000 customers who's trying to pay in cash, I
Yeah.
think it's just the business aspect of it is not making sense. And so this is where we are thinking about things like talking to the main streets and the bids about community cash to card machines, things where you pool collective resources, $6,000 divided amongst, 40 businesses isn't as great an expense, right? So we've really been trying to enforce the law as we are currently required to do while understanding the pressures that businesses face to remain profitable and serve their customers.
Thank you. Given the increase in prevalence of digital payment options, are there other ways to provide options for consumers at cashless businesses that you think address the spirit of the law?
Maybe, I think it's hard that the population of sort of cashless customers is varied, right? So there are people who have all of the means to have cards, but they choose to use cash for budgeting reasons or
Mm.
staying off the grid. There are people who, the underbanked, which I think this was originally intended to serve. We don't really know what that population is right now. And so I think that's part of the reason why we've been gathering the data, looking at who's filing complaints, who this is impacting the most right now. But what we're seeing is, since its inception, since we started doing kind of monitoring in October, we've only had about 24 complaints total. And, some of those are the same business a couple of times. It's like 18 unique retailers.
That's interesting. How wide do you think your reach is on that?
I mean, the complaints are throughout the city. I mean, they're most pervasive in Northwest. We've seen a lot of them there. I think the question of consumer education, whether or not that would increase the number of complaints. But we really want to focus on consumer harm, risk to consumers. And so rather than educating consumers specifically on this law, making sure people know they can file a complaint. You have an issue with any business in the district, you can file a consumer complaint. And so then we are able to naturally see what the challenge is versus thinking about things through a lens of pure advocacy.
And the description you gave me earlier of the cashless consumers that you've come across, is that mainly the complainants you've come across or others you've talked to?
Complainants. I mean, I think just also like my experience as a consumer, and kind of what I've heard anecdotally and what I read in sort of the reasons for enacting the law, and at some of the meetings with the chamber and the restaurant association. So
Yesterday, I asked the council budget office to do a study and report of cashless consumers to better inform the work that we're doing at the council, given the fact that we've now been asked to sort of repeal it, or delay implementation further, pause implementation at this point because you're already doing it.
we are.
Because I fear without some additional study and data of the way consumers have maybe changed or maybe not changed, we're just going to keep having this circular conversation with businesses that don't want to do it. So my hope is that budget office will be able to take that on for us, which would be great.
Yeah, we would be interested in that data, particularly because I think the last one was like 2018, 2019. and
Exactly.
So a lot has happened since then.
Yeah. Excellent. Well, I'm sure if they're going to work on it, they will be in touch because they'll
Okay.
want to talk to you about the experience on the ground as well. So I want to move on to the enforcement of licensure for cannabis businesses. Earlier this month, the council passed the Medical Cannabis Enforcement Emergency Amendment Act of 2024 to address establishments that continue to operate illegally despite requirements outlined under the Medical Cannabis Amendment Act of 2022. Specifically, the legislation requires that any establishment wishing to sell cannabis must apply for ABCA's new medical marijuana program, which closes this month on January 31st. Has DLCP sent correspondence to cannabis shops who have registered for a basic business license with DLCP to notify them of the new legislation and requirements for additional licensure?
We have not yet done that. We've been engaging in a very collaborative process with ABCA, the council member's office, and like our team, our enforcement administrator in particular, our legislative director, and our general counsel, because we were taking complaints related to this and had sort of reserved them for when this was ready. We would send them to APCA, and we were all just kind of waiting for the final touches on this. So now that the framework is clearer, we will be working on joint communications. And I've spoken with Director Musali about that as well. So
that sounds good, except for that January 31st is very soon.
it is. So I think what we're seeing, we've only had one complaint in the time since, or one matter that we've sent to ABCA in the time since the law was updated to present. And so we have sort of I won't say the locations that have been flagged as problematic, because people are very they were waiting for this. We
Mhm.
have some places ready to go that will, be investigated by APCA. And then we will also work quickly to let folks know that they can, file complaints and that businesses are required to do this. We also shared any news story, links to the legislation internally so our teams know, but we will absolutely work this week to get a public message drafted. So I'll have to, since that's collaborative, I won't commit to being able to get it out this week, but we'll try.
Okay. Additionally, the legislation transferred some of the enforcement mechanisms from DLCP to ABCA, but DLCP is still required to notify ABCA of violations from licensed establishments. How is enforcement operating under this new transition?
So prior to the update, we had about 30 cases that we had just shared with ABCA, even though they weren't doing their portion of the enforcement yet. Since the update, we've shared one. We have a very close working relationship with them. Our enforcement team and their enforcement team they communicate a lot. I think we will work on sort of an electronic, more automated way to send those complaints and track them. And, a lot of requests for maps I've heard during the testimony. So, likely legal cannabis operators, but that's, we're not advertising some of these businesses, but it'd be important for us internally to know where the locations are. So.
Makes sense.
Mhm.
Okay, setting that aside, moving on to tobacco enforcement. DLCP is also one of the agencies responsible for enforcement of restriction on tobacco sales, including the flavored tobacco ban. As we heard in public witness testimony earlier this afternoon, there may be an absence of specific enforcement mechanisms for prohibiting the sale of tobacco products to underage individuals. Can you please detail the current enforcement process, including infractions and fines, and what additional support may be needed?
So I was actually very surprised to hear that witness say that we didn't have any enforcement authority related to underage tobacco sales, because we do. We have been continuing the work that we were doing with DBH. We still issue infractions to those who are found to be selling tobacco products to people under 21, any flavored tobacco product, e-cigarettes in a particular location. And so we're still operating fully within the scope of the law. So we're going to follow up with, was it Charles? Was it the gentleman who was speaking about his concerns? And as you heard, I almost didn't give my full testimony because the witnesses did that for me. Basically, everything that I read, the public witnesses said our team has been very engaged with the community and advocates. And so we'll reach back out to Charles and figure out what particular aspect of our enforcement he's talking about and follow up.
Thank you. There was also a request in testimony for more robust tobacco enforcement programs. Would DLCP consider proactive visits and undercover surprise inspections as part of expanded enforcement mechanisms?
So they were doing that. They were doing those. I think one thing, shortly after I started at the agency, there was an incident at a retailer where he was making threats and things like that. And fortunately, our teams know how to handle that. They're not the police. They sort of back up. They handle it sort of, they leave and then they document what occurred and we handle it from there. I think in terms of the sting type activity, we're not sure really what the volume is to see if that's necessary. We're still doing complaint-based activity, but if it turns out that these retailers are back in force, then we'll get back out there. I heard someone suggest that we do a map of violators and post it publicly. I think, if I'm a 16-year-old who's trying to buy flavored tobacco or
That's the
cigarettes,
roadmap.
I'm like, hey, I know this place will do
Yeah.
it. So I'm
Yeah.
not sure that I want to go that route, but
Right.
yeah, we're interested in doing all we can to support this law.
Great. Any other enforcement ideas that you all have?
I think the team has been very active. Predating me, this was something that they were out in the community, taking very seriously, working closely with advocates. And so we'll continue doing that. we have several other laws that came into effect at the start of FY '24. And so we're just working to make sure that we are basing our resource allocation on consumer risk, the types and complexity of complaints we're getting, and balancing that at this time.
Is there data on infractions that's currently shared with other agencies such as DC Health?
I don't think we have a formal sort of sharing agreement with them right now, but we most certainly can. And we will make sure that any data around complaints that we can share is in open data as well. I don't think historically we have shared details like type specific, so like complaint data by type. And so we're going to work to do that because as many agencies can see sort of where we're seeing consumer risk, the better.
Great. It's really nice to have a former Octo chief doing
I
this
know.
work.
I know I have a cheat sheet.
Yeah, but I mean, if all of our agencies started out the work with the idea that open data is a priority, then it would probably shape the way we create things, and it would be a lot easier to make them all talk to each other. So
People remind me all the time when I like try to go straight to the source, like at the agency, they're like, oh no, that's an open data. Like we can do that ourselves. So it's great. It's a
Yeah.
great resource.
would additional FTEs allow DLCP to expand its proactive site visits to tobacco retailers? And would that be beneficial for enforcement?
I think we're being really careful about what we ask for FTEs for. We have some additional FTEs for investigations related to cashless and vending and beneficial ownership, and we're making sure to train our investigators so that we understand sort of what the volume is looking like, that we can, if we're at a peak of vending complaints, we can make sure that we have enough staff who understand how to handle those type of complaints without needing additional FTEs. Now the team, they could always use more resources, but I think right now we're trying to figure out, are bodies better, or is that money better allocated toward system updates and things like that?
Mm-hmm. Okay. I want to talk about noise ordinances.
Okay.
So there's frustration among some district residents about lack of enforcement of noise complaints, as well as the confusing enforcement structure. What enforcement of noise ordinances falls under the purview of DLCP versus Department of Buildings, MPD, and ABCA?
So when I first started, the deputy mayor of public safety and justice added me to the like multi-unit conversation about like nightlife, and that includes noise. And our role at DLCP is pretty small when it comes to noise. We have authority to do investigations into trash truck noise, which is different from sort of the noise ordinance complaints related to clubs and construction and venues. So we are part of the conversation. They reach out to us when they suspect that like a noise violation is also tied to unlicensed business activity. But in terms of having authority over the noise ordinance as it exists right now, we don't.
Just trash truck noise.
Just trash truck noise. We stay informed, and we have an open relationship and dialogue with those agencies, but we don't actually have authority. And I checked several times with the team when I was put on this like nightlife team. So right now it doesn't look like we do. If someone has like read the statute differently or believes that we do, then let us know and we'll look into it.
No, but it's fascinating.
Mhm.
Maybe it makes sense that now this committee has brought all of these agencies together under the umbrella of Public Works and Operations. But, so you are a part of the Nightlife Task Force.
Yes.
Yeah.
we have a different role, I think, than some of the first responder agencies and DPW, but we stay abreast of what's happening. That way, if anyone is operating beyond the scope of their business license, or we see some other area of consumer risk or public safety, we address it.
Yeah, I mean, the thinking behind a lot of the task force work is bringing daytime agencies into the evenings so you can see the things that are going on when you're normally not
Mhm.
monitoring. Has that been helpful?
It has, and we pay attention to whether or not like food trucks are also part of the problem.
Right,
And so it has been helpful to be informed, and just the idea that that government agencies are in sync and having communication is a great one. So we've tried to employ that across all of our mission activities.
do you have any staff dedicated to enforcement of noise ordinance?
So all of our investigators investigate the trash noise complaints. So similar to like gas powered leaf blower complaints, all of those get investigated. There's no kind of threshold for investigation. We get a complaint, we do the review.
And is the nature of that like a private hauler is out too early in the morning?
Yes, I
Okay.
mean, we used to get like, not private hauler complaints about just
Our own
any
trucks.
trash truck they'd
Yeah.
hear. And so then we'd look into it and figure out who it was. But for the most part, yes.
Okay. So you get a complaint, somebody investigates, and
That's
then
right.
if they can issue a citation, they do.
Yes.
Okay.
Mhm.
And those complaints are happening between the hours of 10 PM and 7 AM.
That's right.
Do you have people on duty then?
No, I mean, and most of the time, like, I would say we get more of the early morning complaints
Right.
than the
'Cause you
late.
can't really hear the trash truck at 10
Right.
PM. when there's
And
six
by the
around.
time someone on our team gets them, they're not really real-time complaints in the same way that others are. They're not sending us like audio. We're not going out at 11 PM
With the
to do it.
decibel reader.
Right.
Yeah,
So,
it happens quickly. It's not sustained.
exactly.
So is it even really possible to investigate them?
It is, I mean, and what the team looks at too is if it's the same company 10 times in a row,
Right.
then contacting that company, rather than handling them on a one-off basis, you contact the company and you
Yeah.
say, hey, look, like clearly your operational plan here involves like doing pickups at times that are prohibited. And so then it really allows you to see kind of, is it systemic? Is it just like a couple of bad actors?
Is it just a driver who isn't well trained, that sort
Right.
of thing? Okay,
Mhm.
interesting. So then you don't have any particular tools to do noise measurement at DLCP?
We don't, and I asked the team if they had been asked, like, as we joined the task force, whether or not there was the desire for us to do noise work.
Yeah.
And I don't think so. I think there's already enough like hands in the noise pot, so to speak. But if someone has an interest in having us look into it, we can.
Yeah. We'll talk about it more because there are two measures that have been circulating the council over the years that are going to come back this year. One is the chairman's amplified sound bill, and the other is my Harmonious Living Act. I think mine will be referred to him and his will be referred to me. So probably we'll move them both. But I think one of the things we're going to want to get into is which agencies have that authority, what technology are they actually using? Are we sort of overcompensating by using the fanciest technology when, a pocket decibel reader could help us
Right.
in most cases without infringing upon anybody's rights to, transmit sound?
Mhm.
So, TBD.
Okay.
But it's helpful to understand how limited your role has been as we think through what your role would be in those situations, versus ABCA or MPD.
Understood.
Okay, we can put a pin in that for now.
Okay.
In 2018, the council passed the short-term rental regulation act, which restricted short-term rentals to property owners leasing their primary residence. We've talked about this. We've had a hearing on it. And then beginning December 3rd, 2021, property owners were required to apply for a short-term rental license or a vacation rental license in order to operate and advertise on rental websites. In previous testimony, DLCP has stated that there are more than 60 platforms that advertise short-term and vacation rentals Would you be able to provide a full list of those to us?
Yes, we can provide the list to
Okay.
you.
Are they all permitted to operate in the district?
So we'll probably check that
Yeah.
before we send you the list.
Yeah.
And then we'll be able to like send it in a spreadsheet, like, and if they're not permitted to operate in the district, then that is an investigation we'll have to conduct. Ideally to bring them into compliance, and if they don't, then we'll issue an NOI.
Great. I love a good spreadsheet. So,
Yeah.
all right. Can you provide potential reasons someone would be denied a short-term rental license?
Yes, they are not living in the home, right? And that's number one, and one that we're focusing on, because the idea is to allow district homeowners and residents to use their primary residence for income. So that's number one. Or they're applying for the wrong type, or they were granted a license, but then they're exceeding the limits for how they're using it. So I think the acceptance rate for applications is pretty high. I don't know what the exact percentage is, but it's pretty high for people who are applying, demonstrate ownership, follow the guidelines.
Thank you. I've recently been made aware of potential legal challenges to the Short-Term Regulation Act as currently enacted, and that similar legal challenges have resulted in the overturning of restrictions in some states. Specifically, the challenges are related to the barring of tenants from receiving short-term rental licenses, as currently our law says you must be an owner. Have you been made aware of any such legal threats? And does the agency currently have an opinion on the legal standing?
I'm not aware of any specific cases.
Yeah.
I would say our law says that property owners have to be the ones to apply, but we haven't explicitly barred renters or tenants from, being the beneficiaries of these short-term rentals once the owner agrees. So I think in our case, they would have to demonstrate harm, I guess, if they have applied, the owner has agreed, and then been denied a license on that basis, then maybe, but.
In your opinion, would the tenant and row house short-term rental clarification and amendment act of 2023 remove those potential legal challenges? Because that would explicitly permit tenants to use their homes as a short-term rental.
It might, I'd have to look into it more. And
Yeah.
I think some of the challenges with that we discussed in its previous state
Right.
might be a greater risk, but we're happy to work on that if we want to do something to protect those tenants or give them more rights. We're happy to discuss what could work.
Right. All right, so this legislation also rectifies an interpretation of the current law that's led to different classifications of similar properties for short-term rental purposes. Currently, a row house with a basement or ground level apartments considered a one-unit property with an accessory dwelling unit when located in a residential zone. And this means that the owner is eligible to use the basement apartment as a short-term rental. However, a similar home is considered a two-unit property when located in a residential flat zone, which makes the basement ineligible for a short-term rental license. How would DLCP go about implementing this change if the legislation passed?
I think some of our previous clarifications from the hearing addressed this already, and I checked with the team. We have about 128 licenses that are in RF zones right now that have been approved or active. And so I think we're already sort of supporting the intent of that legislation, particularly with our clarifications to our FAQs and the way that we're processing complaints. I think about 6 were directly impacted by that public change, like people applied and were granted licenses, including the gentleman who testified that day. He now has all of the licenses that he would want. But I think we would just continue doing what we're doing now, which is allow that type of short-term rental.
Great, that's good to hear. Helpful to have that number,
Mhm.
128 in RF zones.
And some of those were even before the hearing, but
Okay.
just it's the 2-unit flat piece that
That
made
kind
it
of
a
threw
little.
it off.
Yep.
Okay, but so that does include now some 2-unit flats.
It does, yeah.
Okay, helpful, thank you. We heard a bit, excuse me, today about the beneficial owner disclosure enforcement that was created under the DCRA Omnibus Act of 2018. And this law requires corporate entities to disclose the name and addresses for individuals who have beneficial interests or control the entity's financials or operations in an effort to address housing quality issues in residential rental properties. Could you please provide a detailed update on the hiring progress for the 5 full-time positions and exactly what stage of the process each position is in?
Yes, so we have filled 2 of the positions. There's one that was recently reposted, so they went through, did interviews, didn't find the exact candidate they were looking for. And then one is in investigations, and then one we held so that we could adapt one of the positions from sort of a lower grade into a higher grade, so that we have an analyst to actually do more evaluation of this beneficial ownership information proactively, so we can see what's being provided, does it make sense? Not the 100% I think that the witness asked for, because there are 54,000 of them a year. But it does allow us to dig in further and improve the way that it's working right now by having that higher level position. So we have like 2 pending, I guess, filling, but 2 are filled.
The one is, you said, in investigations?
Yes.
What
with
does that mean?
CPU. So one of the things that our team has actually asked the Children's Law Center to do is file complaints. Like if you believe that there's a bad actor, someone who's trying to skirt the law, submit a complaint so that we can look into it. And so adding additional manpower to the CPU team, like our team that does the investigations, gives us additional bandwidth to do those kinds of reviews.
So that position is hired on that team, or that one's still in progress?
It's filled.
Okay, so you've
Well-
got 3 filled then.
Yes.
Okay.
But we also have so we've hired several investigators recently, and we have 3 offers out. So they're all going to be trained to do
Got
it,
it,
if that
got
makes
it,
sense.
Got it.
So the way that these positions tend to be allocated is when a law passes, they say you get 3 more investigators. And they will know how to do that, but they'll also know how to do other things.
Sure.
So
I got you. In your pre-hearing responses, you noted that there are a handful of for-profit entities that did not report their beneficial owners, and at that time you considered the organizer incorporator to be the beneficial owner. Do you expect to be at 100% compliance when the 16 entities missing their info submit their biennial reports?
yes.
In your written responses, you stated that 99.68% of the active entities registered have disclosed beneficial owner information. However, as we heard in public testimony earlier this afternoon, these disclosures may not meet the requirements under the law and are not supporting the goals of the legislation to address rental housing issues in that case. These concerns have been raised previously to DLCP. What is DLCP's response to these concerns and your plan to ensure that rental housing quality issues can be addressed?
So one thing that the witness mentioned is that the team had indicated they wanted to wait until we had the new Corp Online system to make these improvements. And that's partially true. Like we will perfect them when we have the new Corp Online system. We're
Yeah.
actively going through that procurement process. I believe our statement of work is with OCP. So we are like ready. We want the new system yesterday. But in the meantime, things like the beneficial ownership information is really helpful for us too. We have an enforcement mechanism that requires knowing who a responsible party is. And so that's information that we need when we need to send information to a business owner for like updates and things like that. It's information that we need as well. And so some of our other projects are actually addressing, points of contact, beneficial ownership. And so while it may not be in the Corp Online system or the specific forms that they've requested, we are working on better ways to collect that information. We were sort of at the forefront of collecting beneficial ownership information in the district. And so that system has just been in place for years. So
I see. And so at this point, before the new database then is up and running, is it too tedious to review each disclosure for accuracy?
Yes, I think since there are more than 50,000, but
Mhm.
we do do sort of periodic reviews if we get a complaint either to the corp team or to CPU. And, you know, we also look, as we've mentioned, at consumer risk. So if people are trying to hide beneficial ownership, in a lot of cases, there's a reason. So we want to look at what other potential risks there are there. Are they renting illegally? Are they doing some other prohibited business activity? So we have an interest in fully investigating these matters.
Great. I'm going to note that we've been joined by our Ward 5 colleague, Councilmember Zachary Parker. We're going to do 10-minute rounds. We'll get to you in just a little while. So you have some time to settle in here. Okay. All right. When DLCP is made aware of an entity that has provided incomplete or inaccurate information, how do you address it? And is there an infraction or another penalty?
So right now, we refer it to our consumer protection unit, and I don't know how many referrals have been made. I think a lot of people still will just contact Corp and then they'll call the person or send an email, gather the information, update the system. So it's mostly compliance based rather than sort of enforcement based at this time. And, you know, we work with the Office of the Attorney General on these too. So just keeping in mind that ideally we're gathering the information. It doesn't do us much good to issue infractions and then not have the information. So that's
Yeah.
our primary goal.
Right on. Okay. Have you heard from the Department of Buildings about challenges they face due to inaccurate disclosures? And is there an opportunity for partnership on the enforcement of housing code violations?
So I haven't spoken with them specifically about this, but we do meet very regularly with the Department of Buildings. There are a lot of issues that we are still jointly dealing with, not because we were formerly DCRA, but because it's in the interest of businesses and consumers that we do. So if it turns out that we need to like have a conversation with them about this, we absolutely will.
Okay, so you got the statement of work with OCP
Yes.
on the new corporate registry online system. Have they given you any sort of timeline? And do you have a timeline from when you think will be up and running?
So this is our second or third round with this procurement with OCP, just changes, updates, things like that. And so we don't have an estimate yet. From our end of things, we're looking at the time frame of ASAP, but
Yeah.
I don't really know. So when we find out, we'll update the
Do
committee.
you have any sense of how long it typically takes a vendor to do the work?
Yes, this is about a year.
Okay.
From the time of start to conclusion, it's a year. Because we do have staff that are ready, we have the requirements clearly documented. They did, I don't know, 6 months of research before I got there into the systems. I'm hoping we can move faster. Plus,
Sure.
we have a new CIO who is experienced in this. So I think hopefully will be the 9-month project, but
You said 2 to 3 rounds with OCP. Is that they're not they're rejecting this statement of work?
they're not.
Or-
More like where we share with them to get feedback, talk about the best way to do the procurement, because there are just a few places where this work can be done. So not too many companies do corporate registration systems. We'd wanted to put it in the enterprise business portal and then found that, you know, some of the intricacies related to beneficial ownership and trade names and registration really require a specialized vendor. So,
Mm, okay.
uh,
So will you have to get a waiver from the CBE requirement?
no, I mean, I don't think so. I
Okay.
think we plan to make sure that a CBE is involved in the project, but uh, if we do, we'll be transparent about that. So,
Thank you. We heard some recommendations from Ms. Osborne to improve the process, including requiring indication of type of beneficial owners, requiring specification of percent of ownership interest, and making filings easily searchable. Are those recommendations ones that you're considering?
yes, I think some of them, you know, she has spoken with the head of our corporations division, and some of them are going to be best implemented by a new system, but some of them we may be able to make slight improvements to. Our corp online system is very fragile because of its age. And so we're very hesitant to make changes that are unnecessary, but that doesn't mean we can't find another way to collect additional beneficial ownership information. And I would say the one thing that I disagree with from Ms. Rhodes' testimony is that we're passive. That team, Rebecca and Dominique, they're very at the forefront. They care about this work. They're subject matter experts and they really want to get it right. And so the fact that we're at 99% compliance for provision of any element of the information is higher than most jurisdictions.
Thank you. Okay. Next, gas powered leaf blowers. All right. So banned in the district, starting 2022. Can you clarify a discrepancy in the number of complaints and the NOIs related to gas leaf blowers as provided in your pre-hearing responses? I'm looking at page 21 of your response. There were 1,978 complaints, 893 NOIs in FY '23, 513 complaints, and 142 NOIs in FY '24. But on page 34, 503 complaints and 118 NOIs are listed for FY '23 and 185 complaints and 38 NOIs for FY '24.
So the short answer is we can calculate NOIs by like the document itself. So a notice of infraction is a single document that gets sent to a respondent. On that document, there may be 3 infractions. And so one count was for like the infractions and one count was for the NOIs. And so we just clarified it. The correct counts are 503 complaints and 185 complaints, and then 118 NOIs and 38 NOIs. So the second number. So what's on page 34
Yeah.
is accurate.
Okay,
So
fantastic. Thank you.
no, and I'm sorry about that. We didn't really, we had our wires crossed about what figure we were going to give. So
That's why we have the opportunity to talk about it in a
Thank you.
hearing. We've also been joined online by our Ward 4 colleague, Councilmember Janice Lewis George, who I believe will go after Councilmember Parker, but if I'm wrong about that, my staff will let me know before my 3 minutes is up. So, I mean, after, yeah, after, you then her?
Yes.
Okay. All right. Well, of course you were going to say that. All
Is he on
right.
this committee? He is on this committee, huh?
He is on the committee. That's true. Okay. Well, everyone's very eager to talk to you, Director, and that's the good news. Okay. As we heard the public testimony earlier this afternoon, the Consumer Protection Unit has expressed interest in establishing a public dashboard that features data on complaints, NOIs, and outcomes, but lack the resources to create this. What does DLCP need to create this dashboard, and what benefit would it provide for enforcement?
So I think in some of our recent hires, we have the resources to do this, right? And we don't want to create 100 one-off maps, right? We
Mhm.
don't want to create a dashboard that's just full of information but difficult to navigate. So we're really undertaking a full review of the existing dashboard, what information is important, how we want to display it. And so, you know, the complaint data, we wouldn't do just gas-powered leaf blower complaints. We would do a map that shows like all of the complaints for a particular area. You could filter by type of complaint. The CIO we just hired, Obi Indu, he is like very familiar with data and dashboards and sort of how you accomplish your organizational goals through the use of technology. And so that's something we're looking at right now. I think in my testimony, I mentioned that we were going to roll out new features for the dashboard. And so enhanced complaint data is part of that. What we do have, though, is a system that was implemented a year and a half ago, maybe 2 years ago, that actually doesn't give us the full picture when compared to the system we had previously. And so we're just trying to fill in those gaps, making it easier to parse complaint by type and things like that. So in the next 6 months or so, we hope to have that resolved.
Fantastic. In your pre-hearing written responses, you said that defining gas-powered leaf blowers in the regulations would help with enforcement and provided an example of one area that needs clarification. Are there any other examples of situations where clarity would be beneficial?
No, I think in that definition piece, I think Mr. Finley was probably being specific about the way we define gas-powered leaf blowers because there are attachments and things you can do to your leaf blower to make it louder or quieter. And so just further defining that so
Mhm.
that we're able to apply the law equally. I don't think it's not a super complicated regulation. It's just one that seems to have a high volume of complaints filed by, a group of complainants and then a variety of respondents.
Do you have the authority to issue that those regs?
Yes, I think we do. I think we would need to figure out what priority it is to update it, but
Yeah.
we do.
Okay, I'm going to turn to Councilmember Parker for any opening statement he would like to make, and then a round of 10-minute round of questions.
Thank you. Thank you, Chairwoman Nadeau. I'm gonna bypass the opening statement and jump right in.
Okay.
Director, it's good to see you.
Good for you.
Let's start with licensing for businesses. And I know the commissioner from Ivy City testified, NEP, which is the National Engineering Products Facility in Ivy City. It is a chemical plant that is operating in the district without a license, and it has not had a license for many years. Can you give a status of where things are with that facility in terms of requiring it to have a license?
So they have a license, they have a general business license. And I think what Sabrina, and I'm sorry, I cannot remember her last name. Was it
Commissioner
Rhodes?
Rhodes, yes.
That Commissioner Rhodes, what she was saying is that the license that they have is inadequate. It doesn't fit the work they're doing.
So
and-
last time we checked, I thought they didn't even have a business license. Do you know when that they acquired that license?
I can check,
If-
but in her testimony today, she mentioned that
Okay,
they were out of compliance for months, and then they paid a fine for being late. Then they were issued the license, the general business license, which is the same type of license they had before. So more than likely, when they paid the fine, the license that they had previously rolled over, they were granted it without sort of additional conversations with the commissioner or yourself or the company beyond them paying their fees and getting the license. I think having read DOEE's reply, speaking with Director Jackson, reading Ms. Rhodes' testimony, one thing we are doing right now as an agency and have already done was check the certificate of occupancy. We did that initially, and they do have one to run this business. All of their disclosures and things are, they're pretty transparent about the high temperature plastic sealants and the things that they do. We also have been discussing with our colleagues at the Department of Buildings whether or not that is the proper use for that certificate of occupancy. And so even though they have an active license, we are not ending sort of our review of it.
that's good to hear.
Yeah.
And for those that are watching, they have admitted and testing has shown that there are toxic emissions coming from this plant. It's in the soil, it's in the air. What we heard from the Federal Environmental Protection Agency is, oh, but it's within helpful limits. Yes, these are toxins. Yes, they could be deadly, but it's within a healthy limit. And I just would say, if we weren't talking about Ivy City and Ward 5, I'm not sure that would pass in a lot of parts of the district. No one should have to live in next to a chemical plant. And so I fully support the agency investigating whether or not there should be stricter requirements. I'm of the mind that there should be. And we are willing to work with you to crack down on this facility. If you could also, and I know you may not have this offhand, just follow up on the dates of them acquiring that license, that
Okay.
too would be helpful.
Okay.
Related to licensing, we have a few notorious slumlords or large scale rental properties where DOB comes out regularly and or other agencies are regularly coming out to investigate because of the conditions of the building. In terms of licensing, and what I'm trying to get at is how can we crack down on these people that are doing bad business and putting people's lives at risk? I noticed in your pre-hearing responses, there were seemingly 225 complaints for unlicensed rental properties.
Mhm.
So I have two questions. Can you just define what an unlicensed rental property is? Is that just someone that's renting out a property and they haven't sought a license with you? Or is there something else you're categorizing under that definition? And then two, for a slumlord that has a slew of violations by DOB, and maybe they're just paying the fees that or fines that they're receiving, what recourse can we leverage via your agency to crack down and hold them accountable?
So do you mind if I'm going to answer all those questions, but then
Yes.
I also wanted to have a quick follow-up about NEP.
Yes.
Knowing sort of what the ideal outcome from your,
We want them gone.
like you
I'm,
want the
I'm
business
very
out.
transparent. We want
Okay.
them gone. We're even exploring eminent domain.
Okay.
This is not your fault, Director. This has long preceded your tenure at the agency. And what I know to be true is that we as a city have tolerated certain things in certain communities because of the folk who live there. Black folk, poor folk, and the same is true in Ivy City. And so now we're trying to leverage every opportunity to crack down on a chemical plant that for a long time didn't even have a license, that the federal government says, yeah, they're emitting toxins to the air, into the air. And we're just trying to explore what options we have to get them out of our neighborhood
Okay.
transparently.
Yeah, and I wanted to ask because the conversations with Director Jackson and others are, they are doing testing still at DOEE and things like that. And so knowing what your ultimate ideal outcome
Yes.
is lets us sort of set the bar about whether or not that's a
And this is
conversation,
not to
right?
say
So
that we don't want any industrial
you want
land
that
or
still to go.
we don't want any factories in our communities. This isn't a NIMBY type argument. It is to say that we think this is a hazard and one that is only allowed because of racist policies, because of who have long lived in communities like Ivy City.
Understood. Now, so for unlicensed rentals, the first question about the NOIs for unlicensed rental activity, typically that is someone is renting out a property, they don't have a license of any type, right? They don't have a single family, they don't have a multifamily, and they're renting out the property.
Mhm.
And so then they'll get an NOI for that. And most of those complaints, they get an NOI and they come into compliance. There are some situations outside of rental housing activity where maybe they come into compliance and they do it within the 10
So
days.
if I'm looking at 225 complaints, but only 106 NOIs, what accounts for the difference in that
So
number?
some of those may be in process.
Got it.
Sometimes
Got it.
people, like the typical compliance period is 10 days. So if someone is like, I actually have my application, I've submitted it, you'll see it's there. And I needed to like have the person in on the 1st and I submitted my license request on the 25th, things like that. And then there are some NOI still in
Understood.
process. So.
So for slumlords, I'm not trying to ask you how to, I guess what I'm getting at is we have some property owners who have for decades, for years, have racked up penalties and fines, and we just continue to let them operate in the district. How can your office crack down on slumlords?
Yeah, so some bad actors will like consider it the cost of doing business to just pay the tickets and continue their practices. So one thing we're trying to do is identify, so right now there's not a mechanism to identify those folks before they are issued the license. If they meet the qualification for a license, which it requires clean hands, which means that they may have had a ticket, but they paid it. We don't always see the full history of everyone who submits a request for a housing license. We check to see if they have any outstanding debts. And so if they have already paid their infractions, if it's been adjudicated, they paid them, then that doesn't show up in the normal course of the application. What we're working to do though is have a better predictor embedded in the way that we look at our data. So you submit an application, eventually we'll be able to run it through our NOI database, which right now we share. We would have to have a sharing agreement with DOB to make sure that we could see those housing complaints. Right now we don't. And then we would review to see, okay, this landlord has X number of complaints. Does that make them a bad actor? So that framework is not in place, but we're happy to work with you if you have some ideas. But our plan currently is to get access to the data, run a check, identify what makes a bad actor.
I know Councilmember Lewis George is going to come up next. I believe she's introduced the legislation. Now, hopefully I'm not getting too far ahead of her. If not, I know she's thinking about legislation that would say if you've racked up X number of penalties, then you can't renew your license. There obviously may be some loopholes with that, but I guess what I'm getting at is that sounds like a great idea that for slumlords who year after year just pays the fine, as to your point, a way of doing business in the district with no real effort to improve things.
I think as we've talked about this before, one of the challenges with that, so there are a few things. One, volume may not be an indicator of risk, right? You could have 3 really bad infractions and then maybe you wouldn't hit that threshold. And you could have 100 small ones, minor. And then the other aspect of that, for a lot of these landlords, they're already housing people. They're housing, in some cases, thousands of people. So we don't want them operating without a license. So there have been lots of discussions around what does that look like? Is there some sort of receivership? Is there a place where the rent goes until they make the proper repairs, things like that? And so we're not going to be able to solve that problem on our own, but we have been thinking about it and really welcome the discussion about how to protect our renters.
Thank you.
Thank you. We'll now turn to Ward 4 Councilmember Janice Lewis George for a round of questions.
Thank you, Councilmember Nadeau. I have a few people that I know will want to provide written testimony, and so I thank you for being so flexible with my team and me today. I have 3 main issues that I want to address with you, Director Crowe. Thank you for your service to the district. The first issue involves an auto tire shop in Ward 4 on Georgia Avenue. My office and the community have been dealing with this business and the illegally parked cars, some with tags, some with fraudulent tags, for a very long time. My office were able to get over, in working with your office, DPW and others, 25 cars towed in October. And I think your office was at this blitz. DOB was there and someone from MPD came later. At one point, we had the Department of Health come out to check for rodents because there were so many cars. We've had fire and EMS come out after the building burned down. It came to a head because there was a shooting in an alley, and the officers could not get in the alley because this same sort of egregious auto tire shop had been reoffending. So I want to come to that first, and I want to use that as an example to unpack some of the questions I have about how things are operating. What we found first, when we first heard from your office, we received information from your office that upon review of the inquiry, the Department of Licensed Consumers was able to ascertain that CarQuest Auto Parts is up to date on their business license and trades as American Auto Parts. However, SOS Motors, which is what their other name is, presumed to be trading as Omega Auto Center, but neither organization has a trade name. SOS Motors is currently in a revoked status and has not maintained an active business license since 2018. Additionally, SOS will need to reinstate its corporate status upon completion of the corporate reporting for 2016, 18, 20, and 2022. Furthermore, Omega Auto Center dealer license is coming up for renewal due November 30th, 2023, but the corporation status is currently revoked. So my first thing is, when we were first trying to get information about this auto place, it sounded like they were switching their names and their incorporations to get around not being an active business or being presumed to be or being in a revoked status. How is someone allowed to sort of just change and switch names to sort of circumvent responsibility with the LCP?
Well, so they're not allowed to change names just to circumvent responsibility. I'm not saying that it doesn't happen, but this is where we would use that beneficial owner information, right? So no matter what their operating name is, we can find the beneficial owner information and then work from there. I think also this is why submitting complaints. And so, no, the team has worked very closely with your office. We have the complaints in this case, but making the point about some of the earlier questions we answered, this is where hey, then we absolutely know that this company might be in violation of the beneficial owner requirement, the trade name registration, the corporate registration, and can be shut down. So one of the things that we have done recently through the BSA and other tools is we've requested authority for towing. So DLCP does not actually have authority to do our own towing. We work through DPW. In the case of food trucks at the National Mall, we work with the park police. And so the timing and bandwidth of DPW doesn't, it requires something like a blitz. But what we're trying to establish is a regular course of operations where when we need to have someone towed, we can call the tow company, we have a list of them, we know which ones operate in the district, and have the tow immediately in real time, right? We have 30 investigators who do this work, they're ready. We just don't have the current authority to tow ourselves, so we rely on DPW, DDOT, MPD to do that towing. With regard to this matter, if there are additional steps that we could take or should take to help, we're happy to. You know that we
Yeah.
are following this very closely, so.
No, I appreciate you all have been following closely and really working closely with my team. I wanted to highlight some of the broader issues, and this is one that you did a great job sort of articulating, that you all have to work with DPW and DDOT and others to do some of the towing. And that's an area that, as we look at oversight for improvement, that we may want to look at what avenue works best for DLCP, as far as being able to do some of the towing that you all need to do in sort of these different ways. And so I appreciate that. The other issue I have is sort of in looking at sort of what is the current status of the SOS Motors, SOS Quick Tires, whatever their name is. After the cars were towed, the business had until November 30th to pay all fines and obtain a clean hands certificate and get a new license. My understanding is that they were able to get a new license, and I just want to understand how that's possible. Sort of why does this business even still have a license when they continue to violate regulations continuously?
I'll follow up on that. I'm sure that my team is like furiously sending me messages on my phone, but I don't have I'm not that talented to be able to switch back and forth, but we'll follow up immediately after this
Great.
hearing with an update.
Okay. Yeah, I think I appreciate that. The greater question then for sort of oversight purposes, at what point does DLCP say to a business or a property owner that you cannot renew a license due to multiple violations or fines until you prove that you can follow regulations? Sort of at what point does that happen and what does that look like?
Yeah, I feel like this is a threshold question for our agency, right? So how do we determine who is fit to do business in the district, right?
Mhm.
This goes across all of our license types. And I think it's part of that research that we're doing. We're building a function. I was careful not to say we're building a team or hiring people. We're going to use the people who already work there to look into some of these areas of consumer risk, because the threshold for rental housing might be different than it is for a auto body shop or something. But what is it that makes you too risky to do business? And we've actually heard from like great actors in the district, business owners who want us to do certain kinds of enforcement so that we clear the way in the marketplace for those businesses that are doing great things for consumers. So it's something we're actively looking into. I don't think I have an answer for you today, but we're like taking all feedback about what that might look like. And even if we just start with 3 license types and say, look, this is what it means to be too risky to do business in the district, we can think about that.
Yeah, absolutely. I appreciate that. I want to move from the auto zone to something my colleague was talking about. I did introduce legislation, a do right by tenants legislation. And so the second issue involves housing and licensing. You heard from Children's Law Center about the frustrations that they have and many other clients have when dealing with housing code violations, and being able to know who owns the property. And in their written testimony, it states the Department of Buildings' ability to enforce district housing code is hampered by the lack of easily accessible, accurate information on the actors being behind single-purpose entities that own property. I think similar to the tire shop issues, there needs to be communication and coordination between agencies. So could you walk me through the process of sort of the consequences of property owners if they have unresolved notice of infractions or multiple fines? And why don't you all have sort of the same information as DOB when it relates to that?
So we technically still share a base land management system, which is Acela, right? Which is where DOB has their information. And we can look at it on a case-by-case basis. We're actually working out a data sharing agreement with DOB right now for several other matters. And so we absolutely will include this in that agreement. So housing code violations for us to see and gaps in beneficial ownership for them to see. On a investigative basis, our investigators now use several systems. So they'll use LexisNexis. They will search for the beneficial owner through several means. And so when we get that information and update the system, a data sharing agreement would allow us to get that information to DOB in real time too. So I think it's coordination, but also recognizing that there's a timing element. We've got to do it quickly. So we'll be working on that.
Great. And then lastly, the do right by DC tenants bill that I introduced along with a few of my colleagues will prevent anyone from getting a new basic business license if they have 5 Class 1 or Class 2 violations within a 12-month period. I know you testified about current residents, but this bill would sort of prevent someone from obtaining a new license. I think you testify that the DLCP doesn't work in a vacuum. So I just wanted to understand what steps you all are taking with other agencies to making it easier for residents to get relief from property owners.
I think one thing that would be great is, so our legislative director, April Randall, has such great, oh, you know her, okay, good, has such great relationships across the district. And so we would love to provide feedback on this bill and also incorporate how DOB and our agency can work together on that. Thank you.
Councilmember, thank you. Are you sticking with us?
Yeah, I have one more round on short-term rentals, unregistered short-term rentals, but you may get to it. So if you do, then I'll hop off.
I did a little bit on it
Oh, okay.
already, so I'm not coming back to that, but feel free to stick around to ask them directly. I'm going back to gas-powered leaf blowers just for fun. But not for a long time.
Okay.
I just, I had to take a little break. Okay. In the agency's written responses, you noted that you provide a wealth of information to the public on the ban. Can you elaborate on what you provide?
Yes, similar to what they did for sort of flavored tobacco enforcement and underage tobacco enforcement. Before this law went into effect, they communicated with sort of the public through the website and advisory. They held meetings. They communicated on Twitter, social media, things like that. We also, when someone is found to violate it, we provide them information about what the law requires. We receive a lot of complaints, and so we believe related to gas-powered leaf blowers. So we believe that the public is educated on, the availability of this complaint source. We investigate all of them. We issue a lot of NOIs for it. And so we've been talking this week, last week in our compliance check-in, that maybe we should start to think about prevention, right? And so working with DOEE to see maybe these people who even know about the law, it's just not worth it to change their equipment. So is there a grant? Is there some other way that we can approach this? Because in a year's time, in a year and a half, the volume of gas-powered leaf blower complaints in the high season has not decreased. So in some cases, a high number is not better. We want to minimize.
We want it to go down over
Yes,
time.
we want it to go down.
with
And
your
so
efforts.
thinking through better ways to actually reduce the actual occurrence of this is where we're heading.
Thanks for thinking creatively about that. Look forward to hearing more. You also noted that you previously asked for videos with timestamps with complaints. Why'd you stop asking for this? Is it a practice you're considering returning to?
I would love to, but it is a limitation of the website. I think they were afraid of like
Crashing it?
ransomware, malware.
Oh.
But I think we should work with our CISO, like the district's cybersecurity officer to figure out how we can do it. There are a lot of places where we would welcome being able to upload video evidence, audio evidence, and so.
Okay. All right, the very exciting category of elevator licensing, which is currently a responsibility shared by both DLCP and Department of Buildings. In your written responses, you stated that DLCP had decided to continue to issue elevator licenses instead of transitioning to DOB for the time being. Can you explain why this transition is not a priority for DLCP? Does DLCP have the capacity to continue this work alongside many of the enforcement areas that we've discussed this afternoon?
Yes, so updating all of the signage and things had not been one of our key priorities. And then the transfer of it, it's a revenue generating activity. So, the volume of work and ability of our agency to do it is not so taxing that it's not worth the revenue that it brings in. DOB at some point might have that as a high priority for their agency, and we wouldn't push back on that. We would be fully collaborative with them to transfer that responsibility to their agency. I think, for us, because it's not creating a problem right now, we just hadn't put it on our immediate roadmap.
Well, that gets to something that we've discussed with your predecessor, which is the fact that so much of your budget is tied to fees and those sort of special purpose revenue creates kind of a weird incentive.
It does.
So I guess just something to put on the list of, when we do a more holistic look at that, how it all fits together.
Yes, if we transfer it, it would create a gap in our budget, and
Yeah.
so we would need to find a way to fill it.
Any idea how much?
I don't know offhand.
Yeah.
I know about 80% of our staff is funded through SPR funds,
Right.
so.
Yeah, understood. Okay. You talked a bit in your testimony about the Street Vendor Advancement Amendment Act, which was passed unanimously by the council, became law July 1st, and it improves the management and organization of street vending by transferring the enforcement of vending licensure from MPD to DLCP. DLCP has been a great partner in this effort, and I look forward to continuing our work together. In your pre-hearing responses, you stated that the street vending amnesty program has received only 3 applications. Could you share any thoughts on why the number of applications may be so low?
Yes, I think unfortunately, initially the guidance was in English only. So we have since made updates to that. We did update our website and OTR's website and had shared the information there. But I think the guidance is a little complex. And so one thing we were seeking to do was get the information about eligibility from OTR sort of proactively, but the sharing of tax information is very tightly, regulated, or there are a lot of rules around that. And so OTR's ability to share with us is limited. And so having that
Having the same
information.
issue, by the way.
But we're working on it, and they're willing to work with us. I think we just need to make sure we come to a good understanding of what the law actually says and the limitations there. But that's one thing, right? Because if we could have proactively reached out to the individuals, we certainly would have. I think also folks are waiting to see kind of the rest of the picture. Because we have the vending zone manager piece, we've got the event to educate folks. We're working with community organizations to make sure that we're providing information. So I think what we'll see is a spike in those applications once all of the pieces come together.
Has OTR been making referrals at all?
I think it's happened in reverse. I'll have to verify with the team. I think people come to us, and then we check with OTR on their eligibility and what is going to be forgiven, and then we grant the folks eligibility. So I think we're working on it. Actually, when I received sort of the pre-hearing questions, and it said that one of the questions was about there's a list of people who could be eligible. I sent a note to my friend at OTR and was like, hey, can we what do I need to do to get this?
Glad to help.
Yeah, thank
Yeah.
you. It was helpful, so we'll work on it.
We also asked for the list so we could help, but we were denied. So I hope you get it.
Okay, well, we'll see. If
Yeah.
he's watching this, he may not like that.
Well, privacy, yada, yada, but, in any case, it would be so great if OTR could help us, refer people into the program.
We'll see. And even if the law doesn't allow it, we'll figure out a way to get more people into the program. They have been collaborative. They've been good partners. We just need to make it efficient too. So
Is the program advertised on the license application or portal or, via workshops or other outreach?
it's on our website. We
Mhm.
have just finished all of our communications materials. So one pagers, sort of materials that are translated, and all of that will be distributed. We go out to the sites daily, and so we haven't been passing out new materials because we needed to make sure that they were accurate, but we will be doing that.
Great, and thank you for those efforts. I heard reports that DLCP is currently only allowing vendors to complete an amnesty application, either a first-time application or a renewal. Despite confirmation from OTR, there are multiple vendors who are currently licensed who are eligible for the program. What's the process by which vendors with current licenses can apply for the amnesty program so they don't have to wait to have their eligible debts forgiven?
Right now, they can just send us an email. It's very low tech. We
Low
have
tech.
it's low tech right now, much to my, dismay, but it's, send us an email, call the phone number and say that you're a current vendor who believes you're eligible for amnesty, and then we'll just put them in the pipeline to check.
Cool. Yeah, that low-tech solution probably really hurts you deeply.
It does a little.
Okay. How will the full implementation of the bill, the law, including the hiring of a vending zone manager in Columbia Heights, improve the oversight of the vending zone and enforcement of the license violations and other infractions?
I think it will give it some structure. I think at first, the vending zone manager uh, will have their hands full, even if it's a sophisticated organization with
Mhm.
ties to the community,
Mhm.
because they aren't a government organization, right? They don't have sort of a cadre of investigators and people who can do rotations and provide information. And so what we will be doing is providing a lot of support while they get the structure in place. We've been talking with Director Kozar at the Office of Planning as they initiate the study,
Yeah.
because we want the vending zone manager to use that information as they continue to build. Like, they'll
Yeah.
obviously be started before that's done, but we want all these things to work in concert. So our authority through the mayor, the vending zone manager's contractual authority, and then the academic piece from the Office of Planning.
Fantastic. I'm going to turn to my Ward 5 colleague for a round of questions.
Thank you. In your pre-hearing responses, question 62, which deals with gifting marijuana shops, you referenced the legislation passed by the council on January 9th of this year, the Medical Cannabis Program Enforcement Amendment Act of 2024. And then you say that if the agency becomes aware of gifting marijuana shops or shops in violation of the policy, you can issue a notice of infraction. You can issue a letter ordering the business to cease and desist in conjunction with the Attorney General's office. And ultimately, you can revoke or suspend a license. Knowing that we are working towards an enforcement period coming up shortly, how do we expedite the enforcement there? So if you issue a notice of infraction, I'm assuming they have many months to comply with that. I guess where I'm going is that our policy, the legislation has already provided corrective opportunities for these gifting shops. How can we get the agency to just crack down? If we find that you are gifting, we will suspend your license.
So, thank you. I could not have written this commercial for the CPPA updates better myself. So one thing that DLCP, it says in conjunction with the Office of the Attorney General, because we don't currently have the authority to issue an immediate injunction ourselves at DLCP. So we can issue an NOI immediately. We can make compliance required immediately. Like if they have 10 days to come into initial compliance, they don't, they get an NOI, then we go back 10 days later, they're still not in compliance, they get another NOI. That will rack up. They won't be able to have clean hands. They won't be able to apply for any other type of business license. We refer to ABCA, who also has additional enforcement authority. But right now, similar to the question that Councilmember Lewis George was asking about the tow shop, the auto shop, we can't issue an immediate injunction. But once the CPPA update that's in process is passed, we will be able to say, no, shut down this activity immediately. Like right now, there's a period where we have to issue a suspension and go through that long process that you mentioned, so.
And what is the average timeline going through the typical process there?
I don't know. So in my time there, we've only done it once. And that was long because it was the first time. And that took about 90 days. So I don't think that's normal. I think it's because there was a lot of sort of like pauses in between.
And the concern here obviously is we have people exploiting the law. We will continue to have people exploiting the law. Some of these people are not homegrown Washingtonians that are benefiting from this exploitation of the law. And it just seems as though what I'm hearing from you is there is not an immediate way to crack down on people.
And I have to say, I don't know what ABCA's authority is for immediate. I think that actually in the law that just passed on the 9th, there are some immediate impacts. Like they can do summary suspensions and things like that. I'll have to go back and check, but that's where sort of our ability to refer to ABCA immediately who now has a lot more authority in this regard, might actually satisfy what you're asking about. And that complaint process, like knowing if there's harm to the public, we can prove harm, they're not properly licensed, then all of the agencies working in concert can address it in a faster way.
Okay, understood. And then I will end with my request submitted to DLCP to investigate a number of institutions, stores, businesses on North Capitol, including Big Ben Liquor Store, the 24/7 Tobacco and Convenience Store, and I won't run through the entire list. I'm noticing the general counsel is the one that responded to my request, which I imagine speaks to the legality of these types of investigations. I will say, Director, I was under the impression that we were going to go visit.
And do a walk?
Yes, we were going to do
Yes.
these visits together.
Yeah.
And then I just got this email saying, oh, we did the visits and there were no infractions. Now, I can tell you, when I just merely walk by some of these businesses, I see the infractions. I hear about the infractions from neighbors for some of these places. Can you detail your process for these types of walkthroughs and visits?
Yes, I would say the team, and this is my error, this was like my communication error, right? Because the team followed our typical process. We get inquiries about an address or a business. They follow the regular investigatory process. They look at whether the business has a license, whether it's properly registered, whether they're operating within the scope of the license, which is why they do the visit. Like they observe what's happening at the business, they see what they're selling, they see how people engage with the business, and then they like write recommendations. So what you and I discussed was more akin to like a community walk, visit, which we do often with the mayor's office and all of our like public safety organizations. And so that's more of like an outreach item. We wouldn't treat that as enforcement activity because we have a dual role, right? We want businesses to know that we support businesses doing the right thing in the District of Columbia. And so there are separate teams that handle those things. And so we absolutely will and should still do the walk. And on that walk, if we observe things that look like violations of their business activity, even though it's a friendly outreach engagement walk, we will make a referral and ask the team to follow back up. And so that was my communication error.
Making the implicit explicit, you may notice a theme here. in Ward 5, we have lots of liquor stores and tobacco stores that are skirting the law and are, in many respects, nuisance properties that are attracting bad actors because, in some respects, these businesses are skirting the law, whether that's selling tobacco, uh, selling tobacco products that are illegal, or merely just conducting business that's illegal, or noticing drug activity or other activity that's illegal and not doing much about it. And so I will take you up on that to crack down there. But also noted for Big Ben Liquor Store that they did have an infraction, and it notes that the business has since come into compliance, and they've requested and now retained their corporate registration. So this goes back to what Councilmember Lewis George was talking about, when there are certain businesses that are not in compliance with the law, your agency leans in, they get into compliance. And I think you framed it as a threshold question. At what point do we say you've had too many of these compliance issues over time, and so therefore we are not going to renew your license?
So I think there are a couple of really important things that you hit on in your question. So one, our agency, I would say previously was not actually fulfilling its full obligation to update businesses about their requirements. Notifications for business renewals is the number one thing that I heard actually in my meetings with council members and stakeholders. So there are a lot of business owners who contact us and they're like, I didn't get a reminder about my renewal. I didn't know I was supposed to do X, Y, and Z. And there is the thought that you're a business owner, you should put it in your calendar, but we also should do what is like a best practice.
Yes.
I get a reminder 3 times when it's like time to renew my HelloFresh account, right? So, it's the least we could do. And so that's the one thing, like making sure we're fulfilling our obligation to business owners.
And would you say that's happening now?
It is now. And we are working to improve it further. So we have reinitiated reminders, and then we also have updated the dashboard. These are all things that we're gonna say publicly, but you asked the question, so you're getting a little preview, but we have made some improvements and we'll continue to do that. But then the second aspect is what types of issues and infractions create a danger to the public, and then how many of those and what sorts of those mean that you've disqualified yourself from being an operating business in the district. And I would say that's a question we're still working on.
Okay. There are communities that are plagued with a lot of these businesses that are not in compliance. And so as much as you can create space for that feedback and those lived experiences versus just a checklist, because my fear is if we just rely on a checklist, we're going to continue to allow bad actors to slip through the cracks. And I too want to support businesses in our community, but also will reiterate, it seems like we tolerate certain business activity in some places in the city that would never go in others. Ward 4 being an example, Ward 5 being an example. But I want to thank you for your testimony. I'm going to end on a high note. This is a question I've been asking all agency directors, and oddly enough, they've struggled with the question. What's one thing that's gone really well over this past year that you can leverage to make further impact within your agency?
I think, there's a lot of things that since I started at the end of September that I'm like, hey, we've done this, we've done that, we've made these improvements. But one thing is that even before my arrival, when there wasn't a permanent director for a long time and the agency was just getting started, the teams were doing a lot of the right things, like community engagement, following up with things. And so being able to use that sort of energy they have to do the right thing for consumers and the public is really what we're leveraging most. That means that when I'm like, hey, this was pretty good, but imagine if we did this, they're ready. And so being able to hire people in critical roles in IT, in legislation, in community outreach and engagement and communications all within the past 3 months is really what we're going to use to propel the agency even further and get at some of those hard questions.
Thanks, Director.
Thank you.
Thank you. We will now have a round of questions from Councilmember Lewis George.
Thank you. Director, just to follow up on Councilman Parker's point, is there any opportunity for community input or ANC input on some of in renewing a license, or is that something that's considered? I'm just thinking about the tire shop. It's wreaked havoc on all of us, the neighborhood, the community, the council member's office, the ANCs. And if we could weigh in, we would probably overwhelmingly weigh in and say they are all of the nuisance they've created to the community, but also very serious harm by blocking alleyways, et cetera, has been an issue. Is that is that at all in any part of processes, sort of a weigh in from the community?
So you mean something sort of like the process when you want to build a 5-story building in a community and the people communicate at ANC meetings, things like that, like where there's a community input. I think I would need to like look into how that, in what situations it works well.
Yeah.
Because what we don't want is to get community input, ignore it, issue the license anyway, and then we have two problems. One, we've like made everybody mad, and we've spent time sort of getting feedback we weren't going to implement. And so I would love to think of a way to get quantitative information, allow for sort of the submission of additions to that information as a part of the process, but it would definitely be something that we have to think about a little bit more.
Got it. Okay, thank you. I'm just trying to
Yeah.
figure out ways to help in that instance. I wanted to follow up on Councilmember Nadeau's questions about short-term rentals. How does your office identify unregistered short-term rentals, and how many of those has your office identified in the past year?
So right now, the short-term rental manager, Steve Thompson, he does with his team, they look through listings. One of the challenges that they were having though is getting those host sites to provide information. It is a big challenge. I don't have the exact number of how many we've been able to identify. I know it's a lot fewer than probably actually exists. And so we actually just issued a subpoena for some of this information from the host sites because they weren't willingly providing it. So.
Got it. I got it. Okay. So you do sort of a regular review for the short-term rental websites and try to match the properties to the registrations your office has approved, but there are a lot that don't list the address.
Right. I mean, right now, a lot of the work is complaint-based. We're actually about to start a campaign to help homeowners understand how they can use the short-term rental program, encourage their licensure. But the flip side of that is making sure that people who are supposed to get short-term rentals are the ones who have them, right? Like people who are properly licensed.
Yeah, that's it, right? I was just gonna say, because right now it sounds like your enforcement process is driven by complaints, but neighbors are often reluctant to file a complaint about their neighbors' activities. And if the number of calls I receive are any indication, there are many more unregistered short-term rentals operating than any of us realize. How do we identify these violators without relying on neighbors who are willing to report their neighbors?
Yeah, so right now we're able to like scan the sites, like they run a program, they're able to do a quick data hit just to get like the preliminary information about, oh, this is an address that's posted in the District of Columbia. It doesn't have a license. So then they get a letter, we visit, we do investigations. Originally that was in the short-term rental program. So previously, before I started, the short-term rental program was a standalone or team. And now that's been integrated more into the business licensing team and the enforcement team. So our consumer protection unit is starting to do more proactive outreach and investigations related to short-term rentals. When we get the information from the host sites, we'll be able to do even more of that.
Okay. And do those short-term rental owners generally come into compliance, or do they stop operating as a short-term rental? Sort of, how do you handle repeat offenders, and what's that compliance look like?
I have to look into that. I know we issue quite a few NOIs and I have the exact numbers on my, um, in my other binder, but, I don't know what the rate of compliance versus, ceasing operations is, right? If you don't live in the property, your only option is to cease operations. And so I'll check on that and we'll get back to you, Councilmember Lewis George.
Okay, I appreciate it. And my reasoning for the line of question is we frequently hear from neighbors who are complaining about unregistered short-term rentals in their neighborhoods. Apartments, buildings don't seem to be a problem because management companies generally catch the violators, but it seems to be a problem in single-family homes and condos especially.
Yes, we're seeing some, like an uptick in complaints about condo buildings. And a little bit of a pickup in apartment complexes, even where the property owner and the lease agreements say explicitly that they're not supposed to do it. So we're working on some proactive and additional enforcement in that regard.
Okay. And is there legislation that would be helpful to solve this problem for the committee to do? Sorry for giving you.
L-
Just
Let me think about this. I think one thing is, the host site's responsibility, right? If they actually provided us information as a part of the requirement to do business in the district, that would be really helpful. And I think, the limitations that are already in the law, just need to be followed. And
got it.
so we're working to ramp up how we make people aware of what's required, make it comfortable for people. People can submit anonymous complaints. So, for people who are hesitant to, submit a complaint about their neighbor, hopefully the anonymity of it will help.
Okay, got it. I want to follow up on one last thing. Councilman Parker talked about it. I guess some of our I-71 shops, which are already going through their process right now. We've had people apply for licenses in locations that are like directly next to, not apply for, I don't even know if they're a legitimate license, but they have business licenses at least. We have a place on Kennedy Street where there literally is a daycare next door to a I-71 shop. When you all are looking at these businesses, I guess how much it goes into consideration of nearby childcare centers, schools, as a way of deciding whether this is something that should move forward?
No, so there are limitations. So the law has prohibitions with regard to location for certain businesses, right? You can't you can't sell electronic cigarettes within 100 yards of a school, middle school or high school, things like that. And I-71 shops have the same requirements. So if something, and they may not be the exact same requirements, but the same limitations, I believe. And so if someone sees that there is a potential violation, they should submit that complaint to ABCA related to the I-71 shops. If it gets to us, if they submit it with us, we'll just get it in the right place. We won't refer them to ABCA, but we will let them know where to refer it next time and submit the complaint on their behalf.
Got it. So I think that's what it is. I think schools are considered, but I think early childcare educators is where the gap, education, early childcare centers are where there's a gap. Am I right that schools are specified, but childcare centers are not
Daycare centers.
specified?
We can actually also bring OSSI into some of our conversations with ABCA as we think about enforcement or if there's going to be future legislation, because this was emergency legislation most recently passed. And so
Yeah.
that means there's probably a pathway to future legislation or updates. And so we work really closely with our colleagues at OSSI with regard to daycare and early child care center licensing and compliance. And so we'll get their feedback on making sure that they're part of the process.
Great. Okay, wonderful. And then I just wanted to end on a positive note. I wanted to say thank you to Inez Sakate from your team, who came out to many of our care days that we do in our community, to your DLCP team that works within Ward 4. I know you may have transitions, but your offices always come out to community days and community events when we have needed them. And they've always been willing to be a resource to our community. So I want to thank the DLCP outreach team, and also those who work close with my constituent services team. You are one of the agencies where, you know, it's never like we can't reach them, we can't talk to them. And so I want to just appreciate your team in its entirety for that work. And thank you.
Thank you so much. They'll really appreciate that. Thank you.
Thank you, Councilmember. Okay, I think we're in the home stretch here.
I should have brought some water up here.
I
didn't
feel
think
like
about it.
someone
I'm
did.
good. We're almost done.
All right, okay.
Thank you.
You see me refill twice. Okay, back to vending zone. Once DLC has entered into a contract with the vending zone manager for Columbia Heights, will vendors who sell in the zone be required to obtain and pay a fee for a site permit related to the zone?
Yes, they will. And I'll use this as an opportunity to talk about a partnership with Director Kirschbaum at DDOT, where we're really rethinking the way that vending site permits work. It's a lot of back and forth for a small part of the process.
Mm.
And so, you know, the idea that there really should just be green zones and red zones, like places you
Mhm.
can vend, you have a license, it's not already occupied by someone, there aren't special restrictions. And so we're in agreement about what the future of that should look like. We just both need the time to put it on paper. But that is something we're going to work with the vending zone manager to get implemented and use it as a model.
Does it require any additional legislation?
We think most of it is like operational and administrative.
Great.
We're going to work with April and the legislative team at DDOT to see if anything is required, but we would probably treat that as emergency legislation if it did.
Standing by.
Great.
Okay. In your pre-hearing written responses, you outlined that DLCP had developed policies on when to involve MPD in vendor enforcement. Can you please elaborate on these policies and detail a situation in which MPD would be involved?
Yes, so we take into consideration that MPD has a very, you know, challenging job, and that we want to make sure that when we use their resources, it's in accordance to sort of their areas of authority and responsibility. So criminal activity, weapons, drugs. Our enforcement team has been coordinating with the business beat team of MPD, and really are refining sort of what that looks like when those referrals come. But in general, they're willing to take our calls. They respond to us when there's anything that is criminal activity. So.
In response to recent concerns around vendors selling stolen goods, which I will reiterate remains illegal and a criminal offense, DLCP has reportedly sent multiple officials to investigate the Columbia Heights Mount Pleasant vending zone area. How does DLCP plan to continue to enforce the prohibition of selling illegal goods?
So DLCP, so one, we don't have the expertise to determine if something is a stolen good, and we would really want to rely on the expertise of the police if we have a strong suspicion that something is stolen, right? And there are things that are clearly illegal, and we obviously will call MPD for that. I think we visit to do education and compliance, and so there are certain things where, you know, just sort of respecting, not blocking the crosswalk and not making it impossible for people in wheelchairs or with strollers to pass by, selling food without the proper license or even having initiated that license. We're really just making sure people understand that those are enforceable activities. And then we keep in contact with MPD. People need to understand that if you see a vendor doing something illegal, that's still criminal activity, and the MPD is ready to do enforcement in that regard. If you see someone doing illegal vending activity, then call us, and depending on what it is, we act.
Yeah, thank you. Has DLCP identified any evidence that vendors in Columbia Heights are selling stolen goods? Or let me ask it a different way. Have you relayed any suspicion to MPD around this?
I'll have to check with the team about that. I mean, I think because we are in communication with MPD when something illegal might be happening. But the Columbia Heights situation right now is one where, I think I recently saw a business say that they were um, concerned, but that is not what we're seeing when we're out there every day recently.
Yeah.
So in the past several months, we're not seeing those vendors necessarily with goods that are from those stores, but if we did, and had it reason to believe that it was stolen, we would contact MPD. I think we are working really closely with our sister agencies on this, and are working to do all that we can. I think not being able to ID individuals who are really egregious without calling MPD. We are not going to detain at DLCP. We're really not going to take that risk.
Yeah.
And so, at some point, not being able to identify individuals who are not trying to come into compliance will be a problem that we have
Yeah.
to solve.
And we can work through.
Okay,
Yeah.
great.
Feel like we're getting closer to that moment,
Yeah, I
right?
think so.
Yeah, understood. What is the expected timeline for the launch of a digital process for applying for a site permit and vending license via the DC Business License Portal?
You can do it now.
Ooh.
The piece that was not done are the translations. And so we're very careful about saying that it's fully complete and that everybody can use it if the translations for the business portal are not done. That's just, part of what we believe as an agency is that if everyone can't access it, then it's not complete. And so you can, in English, access the full sidewalk vending application, and our teams are on standby with the language line and direct support for people who want to come in person to walk through the process.
And when do you expect the language compliance to be in place?
March, I hope, which it's taking that long because after that's in place, every other thing that we add to the enterprise business portal will be translated in 7 languages. So we're really excited about that.
Awesome. When do you anticipate finalizing and publishing the schedule of street and sidewalk vending workshops for FY24?
So we're going to have one first.
One
and
first.
then we will see how well it works. We were very enthusiastic about the single day licensing idea. And then the more we got into planning, and our sister agencies have all agreed to participate, we realized that portions of it, particularly the DC Health portion of it, doing it in a single day, it was challenging. And so we focused our energies on sort of the pre-work leading up to the event, right? Do we have the list of vendors who are eligible, who have already started the process, who are really just waiting on the food handler certificate or need to know how to get a different kind of certificate? Because for people who are selling merchandise, that's basically a 1-day process already.
Yeah.
So
it sounds a little bit like the preparation for this event might actually make it less necessary.
well, we're having one the week of February 27th. but
Okay.
I think the 26th is the Monday. So that week there will be an event. And we're asking people to pre-register. So it's not going to be open to the public in
Yeah.
that same way, but people will have the opportunity to pre-register mainly because of volume. So we're working with the community organizations, our sister agencies, MOLA, and the other MOCA offices to make sure that we have a known set of folks who are coming and that we understand where they are in the process when they arrive and that we can help them specifically.
That's great. And can you describe additional outreach beyond these events that DLCP has conducted to current and prospective vendors?
Yes, so we are out in the community. So not just in Columbia Heights, but in Congress Heights, at the National Mall, downtown. And so we're out not just to issue infractions to violators, but for people who want to vend legally and are in a allowable vending zone, we want them to know how to do it. So
Great. Anything else you want to share with me?
no, thank you for your time.
Absolutely. Thank you for yours. And I'll just do a little closing here. This concludes today's public oversight hearing. For those who plan on submitting written testimony for the record, please do so by going to the Council Hearing Management System at lims.dc.gov/hearings, and the record will close on Wednesday, February 7th at 5:30 p.m. I'd like to take a moment to remind folks that the Committee on Public Works and Operations will be holding 8 more performance oversight hearings over the coming weeks. Please visit the Council Hearing Management System for the committee's performance oversight hearing schedule. To testify at any of these hearings, sign up at lims.dccouncil.gov/hearings. And the time is now 4:48 p.m. and this hearing is adjourned.
Thank you. Thanks so much.